Raj, we can have an intro of Mr. Ramanamurthy Garu, the one who you're talking about.
Yeah, sure.
And then you start playing the video.
Sure, sir.
Share his website first, and then a brief intro about him.
Okay, so my share is disabled for me, sir. Just
we will do it now.
yeah, sure, ma'am. Okay, there you go. Yeah, so Swaravin Pani Garu, he's one of our Guinness Book World Record holder at London. He's one of our esteemed clients as well. I hope everybody can see the screen. So
yes, we can see that screen.
Yeah, so let's hear from Swaravin Pani Garu. In fact, the intro, it's beyond my description. He's one of our esteemed clients who had been through copyright process. Even almost all the celebrities from the musical world, in the world of cinema, had great appreciation. And let me share the complete screen so that everybody can see the video.
సత్యై నమః. ఈరోజు మిమ్మల్ని అందరినీ కలవటం చాలా శ్రీ మహాసరస్వత్యై నమః. ఈరోజు మిమ్మల్ని అందరినీ కలవటం చాలా సంతోషంగా ఉంది. ముందు ఒక పాత కొత్త విషయం గురించి తెలుసుకుందాం. ఒక మనిషి, ఒక పెద్ద ఆయన అమెరికా నుంచి లండన్ ఉత్తరం రాశాడు. అయ్యా మహానుభావ, మిమ్మల్ని కలవాలనుకుంటున్నాను, తమరు గనక అవకాశం ఇచ్చారంటే ఎప్పుడు నేను పరిగెత్తుకుంటూ వస్తానండి అన్నారు. ఆ ఉత్తరం చూసి పాపైన పోన్లే, ఈయన పెద్ద ఆయన కలవాలంటున్నారు కదా అని, అయితే నువ్వు ఒక రోజు వస్తే బాగుంటుందయ్యా, ప్రత్యేకంగా ఆ రోజు మేమందరం పెద్ద వాళ్ళని కూర్చొని ఉంటాం, నువ్వు పెద్దవాడివి, నువ్వు నన్ను కలవాలనుకుంటున్నావు, మరి ఆ రోజు వచ్చేసి అన్నారు. అనగానే ఈ రమ్మన్ ఆయన ఉండేది లండను, వస్తాన్ ఆయన ఉండేది అమెరికా. చూడండి, వెంటనే ఆ మహానుభావుడు హుటాహుటిగా లట్టుబుట్టి అన్ని సర్దుకొని చెప్పిన టైంకి షిప్ లో బయలుదేరాడు. అమెరికా నుంచి చక్కగా బయలుదేరాడు. బ్రహ్మాండంగా చెప్పిన టైంకి లండన్ చేరుకున్నాడు. ఆ లండన్ లో ఆ లట్టు బుట్టు సామాగ్రి అంతా తీసుకొని మహానుభావుడు వచ్చేస్తూ ఉన్నాడు. వచ్చేసాడు, వేదిక వచ్చేసాడు. వేదిక రాగానే ఆయన పిలిచారు. ఆయన ఉన్నాడు కదా, రావయ్యా బాబు, నీకోసం ఎదురు చూస్తున్నాను, నువ్వు చాలా దూరం నుంచి శ్రమపడి నా కోసం వచ్చేసావు, ఇంగ్లాండ్ రావటం అంటే మాటలా, నువ్వు అక్కడి నుంచి వచ్చేసావు, దా అని కూర్చొని అతిథి మర్యాదలు చేసి గౌరవించారు. ఈ మహానుభావుడు వచ్చిన ఆయన ఆ సామానంతా వేసుకొని వేదిక ఎక్కి నుంచున్నాడు. ఇంతకుముందు మాట్లాడాడు కదా, అయ్యా నువ్వేదో చెప్పాలని అడిగాడు కదా, ఆ మహానుభావుడు గౌరవంగా అమెరికా నుంచి నా కోసం వచ్చాడని చెప్పేసి చాలా గౌరవంగా బ్రహ్మాండంగా ఈ లండన్ లో ఉన్న ఆయన, అంటే హోస్ట్ అన్నమాట, ఈయన మాట్లాడారు. చక్కగా మాట్లాడారు. కార్యక్రమం అంతా అయిపోయింది. అందరూ క్లాప్స్ కొట్టేశారు. అయిపోయింది. శుభ్రంగా లోపలికి వెళ్ళారు. అందరూ భోంచేశారు. మళ్ళీ ఆఫ్టర్నూన్ ఈవినింగ్ సెషన్ కూర్చున్నారు. అందరూ కూర్చున్న తర్వాత ఇందాక వేదిక మీద ఇద్దరున్నారు. ఎవరు? అమెరికా నుంచి వచ్చిన ఆయన, లండన్ లో పిలిచిన ఆయన. వీళ్ళిద్దరుగా కబుర్లు చెప్పుకున్నారు కదా. ఇప్పుడు వేదిక మీద అమెరికా నుంచి వచ్చిన ఆయన ఒక్కడే ఉన్నాడు. ఇప్పుడు ఈ లండన్ ఆయన లేడు. లేకపోయేసరికల్లా ఇదేం చేశారంటే, మీ అందరూ విత్ యువర్ కైండ్ పర్మిషన్ అని చెప్పేసి ఒక పెద్ద ఇన్స్ట్రుమెంట్ తెచ్చాడు కదా ఆయన, అమెరికా నుంచి శ్రమపడి ఒక బటన్ నొక్కాడు. బటన్ నొక్కగానే ఉదయం లండన్ లో ఎవరైతే నీ పిలిచినప్పుడు మాట్లాడాడో ఆయన మాట్లాడిన మాటలన్నీ కూడా వినపడుతున్నాయి. ఈ కూర్చున్నటువంటి మేధావులు వీళ్ళందరికీ షాక్ అయిపోయినారు. వీళ్ళందరూ ఏమిటి, ఇక్కడ ఈయనున్నాడు, పొద్దున ఇద్దరు కలిసి మాట్లాడారు, ఇప్పుడు ఆయన లేకపోయినా అన్ని వినపడుతున్నాయి ఏంటి? షాక్. ప్రపంచం మొత్తం షాక్ అయిపోయింది. అయిపోగానే ఎంత గొప్ప విషయాన్ని మీ ముందు మననం చేసుకున్నట్టు మీ అందరికీ తెలుసుండొచ్చు. ఆ మాట్లాడిన వ్యక్తి ప్రొఫెసర్ మ్యాక్స్ ముల్లర్. ఆ అమెరికా నుంచి వచ్చిన వ్యక్తి ఎవరో తెలిసిన థామస్ ఎడిసన్. అంటే మనకి ఎడిసన్ గానే మొట్టమొదటి గుర్తొచ్చేది బల్బు. అదొక్కటే కాదు ఆయన కనుక్కున్నది. గ్రామ్ ఫోన్ మొట్టమొదట హెచ్ఎంఈ అంటారు చూసారా, ఒక హ్యూమన్ వాయిస్ రికార్డ్ చేసిన కనుగొన్న యంత్రాన్ని కనుక్కున్న మొట్టమొదటి వ్యక్తి ఎవరంటే థామస్ ఎడిసన్. ఈ రికార్డ్ చేసినప్పుడు ఈయన కోరుకున్నాడు. మ్యాక్స్ ముల్లర్ చాలా గొప్ప వ్యక్తి. ఆయన చాలా విమర్శలు ఉన్నాయి ఆయన మీద. భారతీయ శాస్త్రాల మీద చాలా ఆయన సుశ్రుత పరిశోధన చేశాడు. మొట్టమొదట మాట్లాడిన వ్యక్తి, ఒక గ్రామ్ ఫోన్ మీద మొట్టమొదట మాట్లాడిన వాయిస్ ఎవరిదంటే మ్యాక్స్ ముల్లర్ది. అయితే ఆ ఇన్స్ట్రుమెంట్ కనుక్కున్న వ్యక్తి ఎవరు? థామస్ ఎడిసన్. ఆయన బల్బ్ ఒకటే అనుకుంటారు, తర్వాత మూవింగ్ కెమెరా కూడా ఆయన మొట్టమొదటి కనుక్కున్నారు, మహానుభావుడు. సో ఆ రోజు సభలో ప్రపంచం గుర్తించుకోదగ్గ సుదినం అది. అంటే మనం కాపీరైట్స్ గురించి, పేటెంట్స్ గురించి కదా మన సంస్థ మనం చెప్పేటువంటిది. అందుకు నలుగురికి పనికిరావాలని నాబోటి వాడు చెప్పేదే ఉంది. ఒక మహానుభావుడు గురించి చెప్పాను. అప్పుడు పరమాద్భుతంగా
Greetings from National Institute for Micro, Small, Medium Enterprises. I'm Swapna, faculty member and head Intellectual Property Facilitation Center for MSME at NIMSME. It's my great pleasure to welcome you all to today's webinar on IPR and commercialization, organized by National Institute for Micro, Small, Medium Enterprises, Hyderabad, in collaboration with Eeva Patent Services and Roots IP as a part of our celebrations of World IP Day 2025. This year, WIPO has chosen the theme IP and music, feel the beat of IP. So we have begun the webinar with a lecture by small brief about the Kalaratna Swaraveena Panigaru, Guinness World Recorder. So this is a day to celebrate the Intellectual Property Day, so which plays a vital role in encouraging creativity and sustaining the cultural and economic impact of the music industry. And it is also a reminder that innovation and creativity, whether in music, technology, or business, deserve recognition, protection, and promotion. At NIMSME, we strongly believe in this vision, and this institute is a pioneer institute under the Ministry of MSME, Government of India, dedicating to the promoting the growth and competitiveness of MSME sector through training, consultancy, research, and policy advocacy. And it is established in 1960, and we are consistently serving as a resource hub for the entrepreneurs, government officials, policymakers, industry stakeholders. And as part of its commitment to the fostering innovation, NIMSME established the Intellectual Property Facilitation Center with the support of Ministry of MSME to provide the end-to-end IP services to MSME startups and innovators. We provide the services like we create IP awareness programs. We also do IP filings, patent search, and also help in IP prosecution, and also provide guidance on the IP commercialization and enforcement strategies. So IP is not only about the legal protection, it is about empowering innovators to translate their innovative ideas, creativity into market-ready products and services. The strategic use of IPR, it may be patents, trademarks, or copyrights, or industrial designs, not only protect the innovation, but also fuels entrepreneurship, enhance market competitiveness, and also attract investment. Today, through this webinar, we aim to provide the participants, including MSMEs, entrepreneurs, academicians, and IP professionals, with practical insights and strategies how to safeguard their innovations and also how to bring them into the market. The sessions will cover all the IP concepts, commercialization strategies, funding options for IP, and also enforcement mechanism, and also the role of AI in the IP protection. And we are honored to have with us all the distinguished panel of speakers. I warmly welcome Sri Gulshan Best, Assistant Director, MSME DFO Hyderabad, as our keynote speaker, and also our esteemed experts like Sri Divya Sridharan, Dr. Bhima Reddy Garu, Sri Vinay Kumar, Sri Vijay Kumar, Sri Vijay Bhaskar Reddy Garu, and also Srinivas Madhapati, who will be sharing their knowledge and experience with us in this webinar. And I also heartfelt thanks to all our empanel partners, especially the Eeva and Roots IP, for their valuable collaboration and also helping us in this particular webinar. And also my special thanks to Kalaratna Swaravina Panigaru for being with us, giving the message to all the participants on this occasion. And let's join together to celebrate creativity, innovation, and entrepreneurship. As a scene, as also today's World IP Day theme suggests, feel the beat of IP. Once again, thank you, and I wish you all insightful and engaging session ahead. So today we will have a lot of deliberations on IP concepts and also how to bring your innovative ideas into market. Okay, so once again, I thank you all. And let's begin with the keynote address by Mr. Gulshan Best, Assistant Director, MSME DFO, Hyderabad. So I request Gulshan to take over and give us keynote address.
Thank you, Swapna ma'am. First of all, good morning to everyone. I would like to congratulate NIMSME to organizing this program, as well as Eeva IP for their support in the program, and all the distinguished IP attorneys, patent agent, trademark agent, and other experts who have joined in this program. The topic of the program is IPR and commercialization. And MSME DFO Hyderabad, we have a scheme under MSME Innovative Scheme specifically for IPR and its commercialization. Under this scheme, we have empaneled 6 IPFC centers in Telangana. One of them is at NIMSME, MSME Hyderabad. And this MSME Innovative Scheme, it was launched in the end of March 2022, and it has got 3 major components, which includes incubation, design, and IPR. In the incubation scheme, we run a hackathon, which in a 1-month window, in which we invite ideas from prospective as well as existing entrepreneurs, and they have to submit the ideas online through the host institution which we have empaneled. We have empaneled around 69 host institutions, HIs in Telangana, and once the idea is approved, we provide a funding of 15 lakhs to the host institutions per idea. And so far we have approved 111 and provided a funding of 5 crore rupees in the 4 hackathons we have conducted in the past. Under the design scheme, we provide financial support for design intervention for existing MSMEs who have been profitable for at least past 3 years. Under the design scheme, the financial support is up to 40 lakhs. Design scheme implementing agency for MSME DFO Hyderabad is at NIT Warangal. So far, we have received 10 applications and they are under process. Under the IPR scheme, we have 1 component in which we reimburse registered IPs, and we provide reimbursement of up to 5 lakhs for international patent, 1 lakh for domestic patent, and 10,000 per trademark, 15,000 per design registration. So as I told you, we have 6 number of IPFC, which is at NIMSME, ICRISAT, Guru Nanak Institute, Vagdevi Engineering College, OUCT at Osmania University, and MLRIT. And we also have 1 TTFC, which is Technology Transfer Facilitation Cell at IIT Hyderabad. We also provide reimbursement. Total reimbursement we have provided is around 500 IP reimbursement, and a amount is approximately 1 crore. just last financial year, we have provided a reimbursement of 178 IPs and the amount to the tune of 45 lakhs. So these are the few support system in place through MSME DFO Hyderabad, which you can take benefit of. And NIMSME is one of the IPFC centers. And as Ms. Swapna told you, the end-to-end services they provide for MSMEs who are eligible. And I also have a presentation, but I think I'm going to pass on that because we have expert IP speakers who can talk about it in a better fashion and enlighten you about how IP is significant from your business perspective, and you can increase the potential of your business through IP registration and commercialization. So I hand over this back to Ms. Swapna.
What is intellectual property right? We all know that it is right or protection given to the creation of the mind. It can be inventions, it can be literary or artistic works, symbols, names, images, and this refers to the basic concepts of our mind. Like whatever you invent, you can get it protected through patents. Whatever you create through your creative work, that is artistic work, literary works, and art, you can protect it through copyrights. And trademarks are symbols, logos, and words which give you a brand identity, which helps you to distinguish between your goods and services from the others. And industrial rights is one more intellectual property which could protect the visual design or the aesthetic aspect of a product, the physical appearance, the aesthetic value of the product. And trade secrets are confidential business informations or any chemical formulas or any secret information, how you plan your business, the strategy, the business ideology can be protected through trade secrets. And patents, trademarks, copyrights, industrial designs, trade secrets are the main intellectual property rights. Apart from that, we have geographical indications as well, which is actually protecting the products originating from a specific region or a geographical area. For example, basmati rice, Kanchipuram silk, Mysore silk, which is originating from that particular region. A Darjeeling tea, Assam tea, which is grown in that specific area, can be protected by the people like the breeders over there, the farmers over there, the tea estate owners together, they can protect it, which is specified to the geographic area. So these are the types of intellectual property rights. Why do we have to protect our intellectual property? Why is it's very important that we protect our rights? Because these intellectual property rights provides the creator, the inventor, exclusive rights, and he can commercialize and monetize his invention, his creation, his design, his brand. Whatever type of IPR is getting protected, he can have exclusive rights, and this rights gives them monopoly for a duration of time. For example, it actually, when you protect the IPR, it actually encourages innovation and creativity, and it gives a competitive advantage for the inventor and the creator, and also it helps in the commercialization and monetization of this idea or the invention. Also, when you protect your IPR, it protects against unauthorized use or imitation or infringing of your creation. So protecting the IPR, protecting your intellectual property is really important so that you get benefits out of it, and also innovation gets improved. So for each IPR, you have a process, and for each IPR to be filed in the patent office, you have to undergo through few processes. First, we'll talk about patent. Patent, we call it as an inventor's shield. Okay, you are inventing some product, or you are creating a new process for an existing product. What you do is you don't want somebody else or anyone to steal your idea and start making money out of it. So what you do is you immediately go and protect your idea, the invention as conceived. So this patent protects the process you have developed or the product you have developed, and both the process and product. What you do is you search for any prior art which is already present, and once there is no prior art, you immediately go and register your idea in the patent office. This is called as filing of patent. Once you file the patent in the patent office, from the date of filing and till the grant, you need to undergo through procedures like examination. Once the patent is granted, you have a monopoly right for 20 years. When it comes to copyright, it is for the, you call it like patent is an inventor shield. Copyright is for the creative source. Here, as a painter, or an artist, or a writer, musician, a filmmaker, they can actually protect their original creative works. Like they can protect their books, the written books which they have published. They can protect it, the paintings, the music, the software code, the algorithm developed can be protected through copyrights. This copyright actually enables them to distribute it, perform it, and also adapt the work into any screenplay. Okay, so and copyright has validity for 60 years and also after the creator's death also. Like it is it is for the lifetime of the user, and this can be protected by filing the copyright in the Copyright Office. Next, it's trademark. Trademark, as the name suggests, it is the identity of a brand or a logo. It is the identity badge where when you have started a business for selling some of your products, first you need to do is coin the name for your brand and also have a logo for your brand, because it helps you to differentiate between your brand from the other brands. So the goods you're selling, the services you're giving to the consumers can be differentiated, because several brands will be for the same product and same services. So to differentiate it between the other goods and services, you need to protect it through brands. And this can be also filed in the IPO, where you get you have to follow a few procedures on the requirements of a trademark. And once you have registered, you have the brand identity for your product and the services, and it has to be renewed every 10 years for it to be lasting forever. And next comes the industrial design. This is an IP which is given for the visual appearance or the physical appearance of the product. Its shape, its pattern, its color, or the lines used, the shape, or the, for example, a bottle cap, a bottle physical appearance, the texture can be protected through design. And this design is first granted for 15 years and also can be renewable up to 10 years and also then a 5 years more. And this design protection ensures that no one can copy your design and no one can make a product which is similarly looking to your product. So this is design. And as the name suggests, the other IP is trade secrets. Trade secret is for a confidential business. Anything which you do not want to disclose it or issue it in the public or want to maintain it as a secret, you can protect it as a trade secret. Trade secret is maintained within the organization. It gives competitive edge for the organization completely, where like the business practice methods, the business strategies, or the process flow, or the method of making income through the business, and chemical formulas or strategies can be protected under trade secrets. Trade secrets, as the name suggests, it will not be disclosed anywhere. It will be maintained as a secret throughout. The famous example is the Coca-Cola formula, which no one has still encoded the formula. So such kind of chemical formulas can be maintained as the secret. This is the way we protect each IP: patent, copyright, trademark, and design. And once this is protected and you get once you get your patent granted or your trademark registered and copyright registered, what you do is you can enforce it. So enforcing it enables us to get the monetization out of it. For example, enforcement is monitoring, defending, and enforcing the rights of your intellectual property. And once this is done, you can start commercializing your product. When you start commercializing patents, you can either license it, sell it, or build a business around it. For example, you can start your own startup. You can become an entrepreneur and start your own business by using your patented technology, either the process you have invented or the product you have developed. So you can start selling your product, your process, and make money out of it, or you can either license a part of it to an already existing manufacturer, so that a part of it, manufacturing can be done by the licensor, and you can get a monetization based on it. Because once a patent is granted, and it shouldn't just lie as a document, you should start monetizing it and start developing the product or the process. The patent has to work, and then only the patent goes to the consumer. Once there is a demand and once it reaches the consumer, you both get benefit out of it, the inventor as well as the consumer who's going to use your product or the service. So patent has to be either licensed for sale, it can be licensed, or it can be sold, or it can be made up as a startup, and then you can develop a company around it. And for copyright, once you have registered your work, you have had a copyright for your work, you can start licensing your work to publishers, streaming platforms, or galleries, because it is the creativity which is protected. So you can start getting it published, and once you start getting it published, you can start getting your royalties. When it is streamed, you get a loyalty. When your music is streamed, you get a loyalty. When it is performed, you get a loyalty. When it is downloaded downloaded through a website, you get a royalty for it. And every time it's getting sold, you get money out of it. So you can also, like, for example, you've created an art which can be sold into products. It can be sold in products like t-shirts, mugs, or any product form. Even the product can be licensed to manufacturers, and for each product which has your artistic work can get monetization for you. And for trademarks, trademarks, we all know that this is a brand, right? A logo. So a customer who trusts your brand, trusts your quality, will automatically come to you and keep buying goods from your brand. So this brand identifies your quality and also your goods and services in specific. And also, even trademarks can be licensed to other business owners who are in align with your company values, or who are aligned with your values, and also who are already in the market, well established, so that it is easier for them to take your product to the market. And industrial designs, how do you get money out of industrial designers? You can either license it or give the design to a manufacturer who can adopt your design to a particular product, and you get monetization. You get money out of your product. And all this can be done only if there is renewal and maintenance of your intellectual property. For example, if a patent has been granted and you're commercializing it or getting money out of it, you can get money only when the patent is actually maintained. For 20 years, a renewal fee has to be paid to the government office for making the patent alive. Otherwise, once it is not maintained, any of the rights, patent, copyright, trademark, or design, if it's not maintained, it can be used by someone else and the monopoly will be taken off. So it is important to renew your patent and keep the patent, not just the patent, any intellectual property alive for getting monetization out of it. And there are, like, we say patent is a huge invention, something like we think intellectual property is something very huge, but it's not that way. Or it's not like, as the slide mentioned, it is not like only big companies can go for IP protection, or only if I have an idea, it is automatically protected, or IP rights are valid worldwide automatically. All these statements are false, because not only the biggest company can have IP. Any individual who's even studying, a student can have an IP. It's just that you need to address some disadvantages or some gap in the market and develop a product or process to address that gap. You get a patent. So anyone can have a patent. Similarly, once you have an idea, you feel this idea is novel, it doesn't mean that you your idea is protected automatically. You need to register your idea, and also this idea is specific to the geographic territory. Once you file a patent or a copyright in India, it has value. The patent has value only in India. Once you make it worldwide, then only you get protection outside India also. So it is specific to the geography, and only when it is registered you have protection. And also it is any IP or anything like a trademark, patent, industrial design, whatever you've spoken about, it is specific to the geographic territory. Once you file it outside only, you get protection outside India. Otherwise, it is protected only in the place where you have filed your invention. So I give a brief on each and every IPR. First is patents. Like how it is mentioned, patent grants exclusive rights to an inventor to make, use, or sell an invention for a specific period of time, and this specific period of time is 20 years from the date of filing. And this encourages innovation by providing a limited monopoly in exchange for a public disclosure. So once 20 years is done, the patent comes public, like anyone can develop your product, because the complete disclosure is provided in the document while filing. So after 20 years, there is no monopoly for that. And that's how generic drugs comes into the market, where anyone can start using the drug. Similarly, examples are pharmaceutical drugs, machinery, software, algorithms with technical effects. And trademarks. Trademark is a recognizable design, sign, or expression identifying your products and services. It helps to distinguish your quality, your brand from the existing brands. Also, it enables to distinguish one enterprise from the other. Trademarks can include either words, logos, slogans, shapes, or sounds. This protects a brand identity and builds consumer trust. Examples: Apple logo, Do It slogan, Nike. These are some of the brand logos. And copyrights, as we discussed, it is for the creativity of an individual. It is it protects original literary works, artistic works, musical and dramatic works. And this copyright is arise upon creation itself. But registration is important so that it gets protected. No one can copy your, like even taking a photograph of your work or photocopies of your work is also copyright violation. So it is important for you to protect your, register your copyright also. And this is valid for the lifetime of an author plus 60 years in India. The examples of copyrights are books, songs, movies, illustration, painting, software, code, algorithm. Software and algorithm is protected under copyrights within India. So these can be protected through copyrights. And industrial designs, as the name suggests, it is for the aesthetic aspects of the article: shape, pattern, physical appearance, ornamentation of the product. And it must be new and original and not functional. For the functions, we do not give design rights. Only for the outer appearances of design rights can be provided. And registration grants is exclusive rights for 10 years, which is extendable for 5 more years. Examples are bottle shapes, furniture patterns, product casings, and any physical product and the physical look of the product can be protected under the industrial design. And trade secrets, they are, as mentioned already, they are actually confidential business information that gives a competitive edge for the organization. Also, it is not publicly disclosed and it is protected by confidentiality agreements within the organization. And this is one right where you do not disclose it or register it. Its protection depends upon its secrecy. How long the secrecy is maintained, the trade secrets remain. Okay, example is Coca-Cola formula, Google ranking algorithm, etc. And to conclude, IP, actually, importance of IP is intellectual property, any property, any like patent, copyright, or trademarks. It actually completely fuels innovation and creativity. And this innovation and creativity actually enhances the entrepreneurship, commercialization. The demands of the consumer is met through creation of IP, and also not just the inventor gets benefit out of it, even the society gets benefit, because the product which has been developed for addressing a disadvantage or a gap can actually enhance the lives of the consumer. So protect your ideas so that it gives benefits for the inventor, the creator, and also for the society. So it is important to protect your idea, and just not protection is sufficient. You have to commercialize and monetize your idea. So the benefits it's a win-win for both the consumer and the creator. This is the base. This is the fundamentals of IP. If you have any questions, you can ask.
I think someone has raised a hands to ask some questions.
Yes. You can either type or you can ask.
Ma'am, as well, I have a question. So, yeah,
Yes,
can you hear me? Yeah. So I was writing a blog. Can I do the copyright for the whole articles that I've written in my blog?
Yeah, article can be protected, but the article should be original, like it should be completely original. If the original article which you have been publishing, it can be protected through copyright.
See, my question is, in my blog, there are multiple articles, around 40, 50 articles are there. So
Okay.
can I protect the whole blog? If I publish an article in the future, can I protect it? If I take a copyrights for only for my blog, can it
So,
be protected to all the articles?
like it will be a website, right? Like the blog can be like a website. So the blog can be automatically protected by copyright law. You can do that.
Yeah. Okay. Okay. Thank you.
Like general facts that you use in the blog will not be protected. The blog can be protected if the original content, the content which you have developed, your ideas and concepts can be protected.
Okay. Okay.
And adding you to the ma'am. So here what we can also do, the participant is like, so main thing for copyright is we need to have certain proof that you are the creator. So one way is putting the entire blog in somewhere or the other, and like instead of, if you want to go for a copyright, you can protect it as a book or some kind of thing, because if you want to register that, we have to register as a literary and artistic work. So if you want to say any literary work, so we should have a title and the contents, index, everything like that. So you can make it as a proper book kind of thing, like a literary format, though it is not a real book. So you can make it as a Word document, put different chapters and try to file for a copyright. You have, and if you are very busy with that one, what you can also do is try to make it as a document. And if you think that there is any threat from the competitors or someone, so even the quickest way is do 2 or 3 posts to yourself, so that it indicates as a proof. Or you can keep your emails as a sent item from your email to the same email ID. So these are simple things, but copyright registration gives you the perfect protection.
Yes. Yes. Exactly.
Hope my screen is visible. Ma'am, is my screen visible?
Yes, make it full screen.
I just made it as full screen, ma'am. Okay, good morning. My name is Dr. Bhima. I'm the manager of IP and Tech Transfer at AICTM Institute.
We are not able to
Can you
hear
be
you, sir.
little
Hi.
louder?
Yeah, ma'am. Give me a sec. Ma'am, now?
Yes, sir. Yes, sir. We can now. This is much better, sir. Thank you.
Okay, done, sir. Oh, hi. My name is Dr. Bhima. I represent AICTM Institute of Education Innovation Center. I'll just, before I get into the main topic, I'll just give a brief of what we do as Innovation Center, being the ministry thing. We actually established this Innovation Center to actually kind of build an ecosystem for fostering innovation and entrepreneurship culture across HES, higher education institutes. And because all of you guys are aware ki a lot of all the engineering colleges, BBA, BCA and all that come under our purview. So we want to build this culture of innovation and all that in higher education institutions and all these institutions. So the objective is to promote and nurture problem solving culture, build a multi-layer sustainable innovation culture, then build an entrepreneurial mindset among the students, then establish innovation and commercialization platform as what MSME is currently doing. Then we do have a lot of, because I just sharing this because a lot of people might not be aware ki we do a lot of initiatives, we do a lot of funding initiative, we do a lot of investor initiatives and all that. That is the reason why I'm sharing this. Because as to institutions like I mentioned, for HES we do have something called as IIC, Institutional Innovation Council, where we give a set of activities for the institutions to take it up for each quarter, and then that is all done, and we do a lot of IPR awareness funding for IPR programs and all that stuff. And we do have an MOE AICT investor network, which I'll talk in the coming slides. And for students, we do run hackathons, IDE boot camps, mentoring sessions and all that. We do have Kapila scheme where we help a lot of startups with patent reimbursements and all that. For teachers also, we do an innovation ambassador program, patent filing help. We do a lot of boot camps for them also. This is just to give an awareness. If you guys are part of any institution, or if you guys want to apply, please do apply for our schemes and all that. And we do have schools under purview also, where we run school innovation councils, Swayam courses for schools also. We do give them mentoring, funding on all that stuff. Because just keep on to the next thing. Here we do run a flagship initiative probably which comes every September to October. It's called a Smart India Hackathon, which is kind of a biggest hackathon challenge across the globe. Currently, we have funded up to 150 plus startups. We do get problem statements from a lot of ministries. Example, like Ministry of Consumer Affairs last year had given problem statements related to tomato, like prevention of tomato spoilage and all that. We had about 6,497 institutions registered for that. We had participation of more than a lakh, and we had 2,887 challenges addressed actually. And next time we hope to see you guys applying for such schemes. And we do run boot camps, and if some students and faculty are here, please do apply for a lot of we do a lot of boot camps across India, and these are all free boot camps, and we do like 5-day boot camps where speakers from Vadvani Foundation do come by and give a lot of training and all that, hands-on training and all that. So if you guys are interested, please do apply. Usually we give a call for applications. Then we do a program called as Kapila. Kapila is a program where we reimburse a patent filing fee and all that up to 6,000 to 7,000 and all that. And we do, as I said, we do innovation initiatives for schools also, like School Innovation Council. We do have Teachers Innovation Ambassadors program and all that. Last year, we gave away funding of 3 crores. Like we funded 200 students, 1.5 lakh. And what we do is we handhold the students, we help them with prototype development, and we give them a chance to present before the Prime Minister of India on July 29th every year. That's a great opportunity for school students also. And we do have an MOE Investor Connect. We did this last year. It's a fundraising platform. If you guys, any one of you are interested in going for pitching and all that, we can help you guys. We do have about 1 or 2 investors onboarded with us, angel, seed funding, VC firm and all that. Last year, when first time this Jan we did that, we had about 14 nodal center identified across India. We got about 10,000 plus applications, 14 screen, 97 investors had come. Hyderabad, we had about 20 investors. And for staff who are actually working in any institution, we do run something called as AICT Industry Fellowship Program, where we ask faculty members to be full-time fellows in industry for a period of 1 year. And we also pay them 1 lakh in fund. Actually, this is a good thing for immersing faculty in cutting edge industrial environment so that they come back and guide the students properly. And let's move to the main topic, IP commercialization. Like, see, generating an IP doesn't have any, like, see, it's good to have an IP, but you need to be very clear key if you want to monetize it, there's some potential when you commercialize it or monetize the IP. Else the IP will be just like a lot of you guys have IPs, but you don't think in that sense. So this is just to bring you an awareness of what you can do with your IP. IP commercialization is a process of converting an idea innovation into a product that can be brought or sold. This is making your IP marketable and profitable in both sense. Ki you get benefit out of it and the person who's buying it gets benefit out of it. If you have an intellectual property, you can build, you can actually give it to somebody else in the current form, or else you can go through joint ventures, partnerships, and make the product marketable and commercially exploit it actually in a sense, because that gives you a brand value, it gives you monetization, it gives you a better reach than just keeping the IP with yourself. Maximizing your, because through IP commercialization, you establish competitive advantage over your competitors, build your reputation. It's a source of competitive intelligence as such, secure market access where, see, as an individual level, where you can't go, monetizing the IP can take you to that level. Identifying potential partners who can take your IP to the next level. Like I said, because I was talking at IP and all that, because we fund up to 5,600 per institute who wants to file patent filing fee and examination fee, we reimburse, and we give up to 100 per institute. And when you have an IP and all that, like see, I mentioned about IP. So there's a lot of investors love for IP. Why should you commercialize IP and why should you have IP? Because when you go to an investor for funding, when you go to investor for any fundraise, they look at your IP because value of intellectual property can increase their brand value as such, right? Can be, and also you can leverage it in many ways like licensing, fundraising, and all that. And it also, see, when you have an IP, it automatically reduces your operational risk, helps scaling up quickly, right? Companies that protect intellectual property are seen as trustworthy partners, right? If you don't have an IP, if you go to an investor, it's kind of key, you're not done your homework, and you're not confident of your technology, or you're not competent enough to have that technology in a sense. Intellectual property can boost your marketing, sales, indicating production and innovation. When you take commercialization aspect, there are three aspects to it actually. One is creating it, protecting it, exploiting it. Creating it is kind of where you create or invent a thing, uh, and you check on if something similar has been done in the market, establish your value proposition. Then the next step would be protecting it. You file an IP, build an IP strategy for that, protect your IP, secure IP, like it's kind of IP protection, file your patent and all that. This is the stage which we call as pre-commercialization. Then comes the stage called as commercialization, where you exploit the IP, whatever IP you have, you just exploit it in a way that you launch it to the market, you partner with other businesses, you license or sell it. There are a few commercialization strategies which I'm going to talk about. Direct commercialization by the IP owner is one strategy. This is a straightforward thing where you are going to start your company, you monetize the IP to produce market or services. Sorry, I'm taking an example of a new speaker with a voice recognition and all that. If you have an IP on that, you start by manufacturing, you're putting the box, your own branding, logo and all that, and you go to the market, you generate revenue out of it. It's one model, direct commercialization by the IP owner, the person who has that, who has the technology and all that. The second thing would be licensing, granting permission to another party to use the IP. It's usually in exchange of royalties and other payments. There are two types in this actually. One is exclusive and non-exclusive. Exclusive is you give it to a single company where it's one licensee, you give it to a single person, and for a region, like kind of region specific and all that. Non-exclusive is you give it to multiple individuals for each region. Like exclusive is given throughout, like if I give it for India, I give it throughout India for a single person. Non-exclusive is you give it to multiple people, like you divide it state-wise and probably you give it to different companies in that sense. Then benefits of licensing would be generate revenue, expands your market reach, allows the IP owner to focus on innovation while others handle production and sales, right? When you give it to other person, the person is handling production and sales. So you can concentrate on innovation, make some better products in that sense. Considerations, you need to be really careful ki when you negotiate such kind of thing, you need to be very careful on the negotiation terms. monitoring of licensee performance and potential for dispute, because a lot of people, when they give licensing, they don't make a proper agreement kind of a thing. You need to be very clear ki how much royalty you're taking, when like stepwise, when are you getting the royalty back and all that stuff. You need to be very clear of. And licensing usually comes into play when the owner lacks the means, necessary knowledge or marketing plan to develop a product, to sell a product or service. The licensing approach is an important instrument for commercialization. Then the other one would be technology transfer, like moving a technology innovation to another organization, often for commercialization. You give it to an organization which can do that stuff. Licensing of research findings and all that come under this. It can lead to rapid commercialization and creation of new ventures, but you need to be really careful when giving it of careful assessment of the technology, market demand, and potential partners. You need to be very careful of. And one more thing would be a joint venture. You can join, you can collaborate with another party who is in a similar space. Like if you do a medtech device, you can collaborate with the other person who is already in the market, and you can it can be involving sharing resource on expertise. Sorry. Because benefits of this is access to new market, because the other person is already in the market doing some business. You collaborating with him will bring the product to the market in a faster way, and also it opens up new distribution networks. You can share expertise, sharing will be there. Sharing of risk and cost is one thing. Potential of synergies. Considerations you need to have is real careful selection of partners is one thing you need to do, because people in the similar domain to need to be identified. Negotiation of agreements need to be done on a very careful thing. Management of a joint venture is to be done very carefully. Then other strategies which you need to follow, you can follow, is like franchising, granting the right to operate businesses under recognized brand. Like lot of uh, franchises are coming up. Spin-offs is creating a new company based on a specific innovation. These days, a lot of, see example I take, spin-off is like Kia is a subsidiary of Hyundai kind of thing. You're creating some spin-offs of a different technology, right? So that is that thing. Key considerations for successful IP commercialization is business goal alignments. Ensure your IP commercialization strategy aligns with your business goals. See, you're working in a specific domain. Don't go and sell your technology to somebody who is totally irrelevant to your technology. Don't do that thing. IP portfolio management is where you need to see, when you're going, you need to manage your IP portfolio very carefully to maximize its value and potential. Else you are losing on things, right? Market analysis, understand the market need for your IP, target the right customers. Understand, because in that only market analysis, you need to understand the competitive position, like see of your competitors and all that. Identifying opportunities and threats is one thing. Understanding competitors' strengths and weakness, based on which you can develop your IP, you can bring demand for your IP. Negotiation and legal support is one thing which a lot of people miss out on. Engage legal. See, not everybody is good at what others do. So engage legal professionals to draft and negotiate agreements, ensure your IP rights are protected in a right way. And continuous improvement is one thing which is very much needed. Monitor your performance of your IP, make adjustments so that you improve upon it. You can go for another IP based on that, and probably you can sell it off to another company. Approaches you need to have when you're doing IP commercialization is market research is one thing. One of the most important practices for IP is market analysis. Like check if there is a demand for the product or service, rivals, similar items and all that. Geographical markets, like see which countries would need your IP. A lot of people think, yeah, I can sell my product here in India, that makes sense. No, 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 don't think that way. Check for countries which where your IP can be commercialized. It can be another country. A lot of medtech devices these days are sold across the globe apart from India. There are a lot of products which we have helped commercialize and all that. That will actually estimate the value of IP, size of your market, and that will also help you say when you know when you have done your market research and all that, you can become very clear of your IP potential. And when you're negotiating with the person whom you're commercializing it, you can actually demand the right price. IP audit is one thing which I recommend to a lot of people. Might not be aware that IP audit should be, you know, when you're going to a larger scale, please do an IP audit. IP audit is nothing but evaluating, protecting, enhancing your IP, fixing weakness in your IP, utilizing underutilized IP. See, a lot of people when we file an IP patent and all that stuff, there are a lot of, when you develop some technology, when you do some research on that, we look at a single point of thing and we patent that. So there are a lot of aspects to it which you don't patent on. So this is more to that. Then identifying risks is one thing. Then IP valuation should be done to accurately estimate the worth of your IP. Classical technology transfer thing would be like, as I mentioned here, what you academy or R&D would do is identify a problem, technology and idea opportunity, you do a proof of concept and all that, product demonstration. That is the stage where you go to. And industry comes into a stage where you have developed a prototype, we go for trials, we do a we do a proper production and bring the product into place. And as you see, key proof of concept to trials is the stage where we call it as gap value of death, where a lot of people like, as any innovator, we think our idea is good and anything can be commercialized and all that. So that is where we lose on. This is just to see when you're talking about some technology, IP commercial and all that, these are few things which you need to be mindful of. No one can accurately predict the true market based on the new technology. License should be designed so that both parties realize take an IP value. It should be beneficial for both the parties. Remember the risk the commercial partner is taking. See, when you're negotiating, be mindful of the partner who's taking your IP is taking the risk on you in that. Sorry. The commercial partner probably understands their industry and business assumptions better than you. So listen and respect their knowledge. That is very important when you do that. So I'll talk about this is just I want to talk about few fundings which are available across various like DBT, DST and all that, so that you guys take advantage of that. I'll not get into it. First thing would be, a lot of you guys might be aware of Startup India Fund Scheme. It provides financial assistance up to 50 lakhs for startups. Only requirement would be a startup recognized by DPIIT, incorporated not more than 2 years ago. And major requirement would be startup should not have received more than 10 lakhs of monetary support under any central or state government scheme. And shareholding should be like Indian citizens should be kind of 51%. There are few steps. The basic steps in would be key. You go to the Startup India Seed Fund portal. You click on apply now. You get 2 screens of incubators and startups. Incubators is closed. So just click on the startup thing, apply now. You create your login credentials like what is seen in the image. Just apply. And you here too, you get choice of 3 incubators. Be mindful you get choice of 3 incubators here who have the fund. So you need to carefully pick those incubators who are aligning to your domain. If you're not applying, if you're not selecting incubators which align to your domain, then probably there's a risk of you not getting the fund. Nidhi Prayas is one scheme which is idea to prototyping grant. The maximum funding is 10 lakhs. I would tell you this is the most easiest funding scheme to tap in. If you're looking for idea to prototype grant, then I tell Nidhi Prayas is one of the best thing to tap in. And what is not supported here is long-term research project like doctoral research and all that. And projects related to software development are not supported here. It's simple. You go to the Nidhi Prayas portal, click on the Prayas centers, which I just highlighted there. Go there, check on the region wise you're looking for. We do have west, south, north, and east. Just check near the call for application if it is closed or open. Few incubators are still open. If you guys are looking for funding, please do go there. If the call is open, do click on it and see if it aligns to your interest of domain, then apply for that. Just you can, if you want to check what kind of schemes, what kind of projects they are funded and all that, go to Prayasis. You get a list of incubators which are having the fund. Click on that, you get incubator list of startups they are funded and all that. There are few funding schemes from BIRAC, because BIRAC is called a Biotechnology Industrial Research Assistant Council, but it's not biotechnology as it's a mix of lot of things which they fund. BIG is a very flagship program which gives a grant of 50 lakhs to support innovative ideas. Seed fund is one thing which they have, which provides equity funding for promising biotech startups. Lead funding is another thing where equity funding for startups which work on medical, diagnostic, and biopharmaceuticals. ACE is another platform where we Bayrak connects you to angel investors and all that. You guys might be aware that angel guys are who fund you up to 2 crores in funding, and VCs come in the later stage. And one important program they have is product commercialization program, where Bayrak provide financial and technical assistance to startups to help them get their products to market. This is a very great scheme, open throughout the year, and you get up to 5 to 10 crores in funding through this. I give just this is just to show you ki what kind of there nothing related to ki you need to do high tech stuff to get all these grants. No. See, it can be an integration of biotech with anything like engineering, artificial intelligence, IoT, and all that. I would just mark 2 examples here. Sorry. Value-added products such as nutraceuticals, poultry feed, aqua feed from waste of palm oil mills and silk reeling industries. And the second one is 3D printer filaments that are biometal based and eco-friendly. This was developed by IIT Hyderabad guy. And they do give another calls for CIPRI, BYPP and PACE, where you need to have an industry collaboration for your startup and you get up to 5 to 10 crores in funding. Bayrak also has launched something called as BioAngels, where they are partnered with Indian Angel Network, one of the premier VC firms in India, to support biotech startups. Then these are few, if you're working in agri space, agri food, then these kind of grants are very much helpful. Like, see, I just put an example of RKVRA Raftar scheme from Tirupati, like Agriculture University Tirupati, and here too we do have that in Idea now, where they give 5 lakhs for idea stage, like pre-stage, where you have just have an idea you want to develop into a prototype, they give 5 lakhs in grant. And if you have an idea you want to come and take it to the next level, they give 25 lakhs in funding. Then this is one good scheme from AG Hub, Catalytic Capital Assistance Scheme, where the call is currently open. The last date is today, but the last date is today. It's focused on agri-tech, animal husbandry, biotech, and all that stuff. If you're looking, if you have developed a product and you want to go to the market, you need some testing, right? So AG Hub can help you do that, and you get 40 lakhs in funding. And there's another call called as Nidhi Year, which is for graduating students to take up entrepreneurship and fellowship. They get up to 30,000 per month with a minimum cap of 10,000. And Campus Fund is one VC firm. This is probably, I would tell you, this is the only, I just highlighted this to show you that ki Campus Fund is the probably few of the VC firms in India, especially funding student entrepreneurs. Thank you. And also, before I close, I just want to tell you guys that we are coming up with the industry fellowship program. AICT and Ministry of Education is coming up with a industry fellowship program where we actually are, that's going to come up in the next 2 months, and we are going to give a scholarship of 37,000 per month for any student who is going to start a startup. That is for any student who has just an idea, want to build a startup and all that. And if you have a team of 3 people, 3 of people on your team get that also. That's for a year long, and we give up to, again we give a other grant of 1 lakh to 2 for supporting your other expenses and all that. That is one thing. Thank you guys. Thanks for your patient hearing.
Thank you, Bhimareddy Garu. Actually, it was a very insightful session. You have given a lot of information regarding the funding that your IICT is providing through your various schemes, and also on IP commercialization, how they can get the support. And if anyone have the questions,
Hi, sir. The
Hi, ma'am.
Nidhi Prayas is semiconductor technology applicable?
Yes, ma'am. Yes.
Okay.
Anything apart from software is always eligible for Nidhi Prayas. Be mindful that the call is about to close, so just check for the institutions having it and apply as fast as possible.
Sure. Thank you, sir.
Thank you, ma'am.
Sir, how to apply for this fellowship program?
Which one, ma'am?
That you told this before, no?
Fellowship
So-
program. Actually, the call, because you need to be watchful of, you just need to check our AICT portal. Probably the call is supposed to be coming in next month. Just check our AICT portal, sir. Ma'am, I can't hear you, please.
Good morning, sir.
Good morning, ma'am.
Sir, myself, Dr. Kumari from Cyber and Behavioral Sciences.
Mhm.
Sir, actually, AICT will give recognition for the engineering colleges and the patents will be reimbursed. Whether the dental college student can apply for patent reimbursement?
Ma'am, actually, if you register your institute under IIC, na, because any college can register under our IIC. We call it as Institution Innovation Council. IIC, it's a very simple procedure. You need to just go to our, you just click on IIC, AICT in Google. You get a list of documents. It's just simple. You need to fill your principal, vice principal, and all these details, and you get your institute registered under that. Then you become eligible for all this thing.
Sir, any particular time for registration, sir? Or throughout
No,
the
no,
year
ma'am.
can
It's
go?
open throughout the year, man. It's open throughout the year.
It's online. Is it online, sir?
Ma'am?
Is it online registration, sir?
Yes, ma'am. It's purely online registration.
Okay, sir. Thank you so much.
Thank you, ma'am.
So thank you so much, Dr. Bhima Reddy Garu, for delivering this such a powerful session. Mainly your strategies on IP commercialization and funding have provided a roadmap for startups looking to convert innovation into impact. We are completely inspired by the initiatives which you have highlighted, sir. Now I'm delighted to introduce our next speaker, Sri Vinay Kumar Thiruvaipeta, a seasoned security expert from FI Networks Inc. With rich experience in the domains of cybersecurity, data protection, and digital transformation. His deep insights into how artificial intelligence is shaping IP production and management will give us a powerful perspective on emerging technology. So please join me in welcoming Sri Vinay Kumar Thiruvaipeta. Over to you, sir.
Thank you, Raj. I hope I'm audible to everyone.
Yes, sir. We can. Yes, Vinay Garu,
Okay,
we can hear you.
Thank you. Let me share my screen.
Yes, sir. Probably.
Yeah.
Yeah, full screen. Yeah. Thank you so much.
Done. So yeah, today, thanks for this wonderful opportunity. Let this session be a little bit interactive. If you have any questions, you can raise your hand. I can stop by and answer your questions. And yeah, let's dig into the topic. Today we are able to discuss on the understanding the impact of AI and on IPR protection and the management. I myself, Vinay Kumar Thiruvaipeta, and as Raj said, I've been working in this IT security domain for quite some time. I'm currently associated with FI Networks. So over to the topic. So before I just jump into how AI is shaping the IPR and domain and your intellectual properties and copyrights and patents and whatnot. So let me, for the sake of the general audience, I'd like to discuss a little bit about AI, ML, DL, and what they are. So can anybody tell what AI means for you and what does it come to your mind when you think of AI? Anybody? So, okay. AI we all know, it's a buzzword these days. It's artificial intelligence everywhere. It's basically AI has been termed in somewhere in 1950, 52 or 53. I think 1956 by John McCarthy. He's called the father of artificial intelligence. It is not a new term that has emerged recently. In 1956, John McCarthy is the one who coined this word for the first time and introduced to the rest of the world at Dartmouth College, somewhere in US. And from then on, people started using it for quite some time, and then but the exponential growth we have seen it in the recent past. But there were studies going on. Research was done on various stages right from the day it was coined, from the day 1956. So it's nothing new, but yeah, it was existing for quite some time. So AI is the overall in general the definition, the book's definition. You can say machines acting like as smart as human beings. So all your the well-implemented apps like Siri, Google Maps, Copilot, and the AI engines that you are seeing, they have now that these AI engines have come or emerged in such a way that they have amalgamated DL, AI, generative AI, ML, everything into that. That's how they are able to, prompt you back or give you responses, whatever your question be like. It can be text, picture, image, audio, because they are now they have capability of, answering your questions based on, whatever media that you give as an input. So AI in general is machines acting as smart as human beings, and the examples are Siri and Google Maps. And ML is a subset of AI. It's algorithms running learning from the data. So whatever data that has been gathered over the time by various organizations from the end users, like your personal data, your work data, or your journey data, whatever information that's available, that has been all gathered, categorized, and split into logical chunks, and then this logical data has been fed into a lot of algorithms so that they can make some decisions based out of that. So machine learning is all about learning, the machines getting learning through various algorithms from the existing data. Like the classic example is like the movies you watch in Netflix, and you get immediately the next movie recommendation that you get from the Netflix engine. So these engines are fed with a lot of data with various parameters into it, and that's how once you select a genre for your for watching a movie, all the next movie recommendations are based out of that. So
कोई भी यार में चलता है एचडी से ही है रे बाबा
Okay, sorry about that, sir. I'll mute them.
yeah, it's okay. Okay, thank you. So next thing is DL. It's deep learning. So DL is again a subset of ML. So ML using various frameworks like neural networks and complex other networks, and use that data, whatever learning the machine has done, or using algorithms over the data. So deep learning is like using those decisions and act on it. So it's like whether a face is matched, whether your fingerprint is matched, the way you walk, you have been recognized by a CCTV camera, based on your demographics, based on your physical appearance. So all these things are the outcome of the deep learning algorithms. So usually the self-driving car, they learn, right? So you feed a lot of data into the engines, and that's how a car will learn. And once it is left on the road to drive itself, so whatever learning it has done in the actual setup, during the machine learning process, so all those learning will be put on, so that this car will be able to drive itself on the road, making the decisions dynamic on the time, real time. So again, data science is a very a 3,000 feet high term. It's used for everything like AI, MLDL, and all this stuff. So this data science usually deals with how the data should be fed into, what insights you have out of the data, and what problem you're trying to solve. Like, the radiographic information that is fed to the doctors. I mean, thousands of radiographic images are fed to engine, and then it tries to detect a particular problem. And that's how the engines are getting smarter than the doctor these days. So these analyzing those images is one of the outcome of the data science. So this is the basic definitions of AI, ML, DL, and data science. Now coming to the AI, back to the back to the focus. So it refers to systems that can simulate human being, the smartness of a human being. So these days you would have seen a lot of robots which are trying to mimic the human being by physical structure and the emotions and also a lot of other factors. So these AI technologies actually they learn right from the machine learning algorithms to the natural language or large language models and generative AI models. So these have been evolving over day by day and making this efficient and recently, we have seen a lot of humanoid robots that have been used, replacing human beings in the factories and manufacturing plants, and making the plant more efficient and making it run 24/7. So actually, the today's topic is about how AI can be leveraged into the IPR, the intellectual property. So I think I don't have to introduce you what does the IP mean for the sake of the audience. So we'll just move ahead and start discussing on the importance of other topics. Today, the importance of IP in the digital age. Today, you're seeing there's a lot of digital presence. Everybody is digitally connected, and there's a huge digital landscape, and all your intellectual properties, whatever you have, like copyrights, trademarks, and patents. So these also play a very crucial role, and how to protect them. Because earlier it was, back in time when you have an idea and somebody tries to impersonate or copy that idea, it was very difficult for you to, to verify to what level it has been copied to, or who is using your idea, copying your idea, in which corner of the world that is being used. So these things are very difficult right now with the digital age. It is on the tip of your fingers. You will be able to know who is actually doing it and copying it and what use cases they have been used to use and where is your idea, where exactly your idea has been copied and what use cases they are trying to use it. So it is very easy now, but the thing is you have to be very, very aware of, and because it is on the flip side of it is that your idea is available, everybody can see it. It's available for the people to, consume it. So it is prone to all these attacks. So that is where you have to be very, very cautious about, about your ideas and how they are being used and how they are being published. So the actual topic of it is the intersection of this IP, AI, and IP. So we have seen that how AI technologies have been, advancing every day, every day. There's a new algorithm that is breaking the yesterday's algorithm on the benchmark of, number of tokens that has been used, or number of CPUs that has been used to, solve a problem. And reducing the computation power and increasing its performance on a daily basis. So each algorithm is trying to break their own record, if using the number of transactions, the performing the number of transactions with the limited time. So with these things in place, there are a lot of questions that people might have, like how our IP has been protected and where it is, how it is published. So how do we know if somebody is trying to impersonate or somebody is trying to come copy your idea? So the impact of the AI on the intellectual property is, how because AI is currently, it is trying to write stories and, creates art and invents products. And these days, you would have seen in the recent past, uh, it is trying to, compose music too. So there are AI engines who are trying to compose music. So there was a recent event where somebody has actually asked one of the AI engine to generate a happy birthday song, which is unique and for his wife. And when he played it to his wife, she was very happy. But later, when she found out that it has been derived, generated by an AI engine, I don't know what happened to their marriage right now. But yeah, the AI is actually covering every aspect of our life right now. So in fact, I'll down the line we'll also discuss how we can leverage this AI to protect our IP. So, but the problem remains, if the work is generated by AI, then who owns it? Is it owned by the organization, the company which owns the AI platform, or it is owned by the person or the end user who has actually asked for it? So there's a lot of confusion still that is exists in the world. There's no guidelines or no proper law that is actually protecting, because it can be a prompt engineer. I mean, whatever data, whatever images, or work or piece of image that has been generated by the AI, whether it is owned by the prompt engineer or it is owned by the platform which is owning the AI engine itself. So that clarity is not yet there, but there are works going on around the world. Currently, Middle East has actually started a group of what do you call data scientists, to come up with the laws and how to use AI ethically. So that is where the world is trying to move and generate the laws around the usage of AI in various aspects. The copyright and the AI. Again, copyright is part of IPR. So AI got the capability to replicate, to produce the creative works, and that further complicates the copyright enforcement. You see, because you are generating an image, and so recently, one of the wildlife photographer, he has fed a lot of his photos to an AI engine and asked it to generate a totally new image, and it generated, and he posted it in one of the competition, where it was selected for some of the jury has selected it for a special category. But later he himself revealed that the actual images is generated by an AI, not by camera. So they can dig deep into that stuff, and they will lay down special rules from then on, who can participate, and how they can predict, or looking at the image, they can say whether it is AI generated, or it is actually being clicked by real life photographer. So there are more number of frameworks that are coming up down the line. You can search in Google how to detect an image is AI generated, or these days the universities and colleges are now using these type of frameworks to check whether any essay composition, or any literature work that has been submitted by students is not AI generated, and it is done by the student itself. So these type of engines will also, the flip side of using AI is that they also check whether this been generated, or it is really done by a human. Again, the patents, as you can see, because of the technological advancements that are happening around the world in various fields. So the question still remains, like, who actually owns it. But you have to be very, very careful, while you are searching for any new idea in Google. What really happens is the search engines like Google, and they have a special privacy laws across the world based on the country that you are trying to search in from. So they collect this data, store it, and that is where the Google learns itself, and somebody else. Your question might be an answer to somebody else prompt. So you have to be very careful while you are searching for a new idea, and I suggest not to go ahead and type how does the new ECU protocol will work in a car, or you have a special idea about how the ECU should communicate with the rest of the multimedia in the car, or GPRS systems that communicate each other in the mobility domain. So you have to, if you start searching it, and the Google learns it over the time, and somebody else who is trying to search in the same domain, and that this work can be published to them, and they'll be aware that it's a totally new thing and nobody else has done it earlier. So they can go ahead and file the patent. So while searching, I sincerely request you all, make sure that uh, you don't search it in a general search engines, rather depend on special search engines that you have, or I rather suggest you to approach an IPR engineer who can help you out with. They have the ownership of worldwide databases, and they can quickly search with the keywords, and so that there are no traces left for you to fear. Similarly, it's trademark also, just like copyright and patents. Trademarks are also, becoming a brand creation, and business must, they have a fear of potential infringement all the time. So the questions is that remains unanswered till now is, who is the creator? Can AI generate content by can that be copyrighted? Can AI invent something, and you get a patent out of it? There are real life incidents that recently happened. Some I listed here. The Davos AI case, South Africa, Australia. This the first AI listed as an inventor, but most countries rejected it, citing only humans can be inventors. So there is a special case in Australia and also reported in South Africa, where the AI engine has generated a whole new idea, generated a patent draft, and applied. Somebody applied on behalf of the AI engine and asked it to be granted, because there was no laws which is defined who should actually own the patent. So because that piece of ownership was missing in the book of laws, so in Australia, that patent was granted to the AI engine itself. Again, most of other countries in the world treaty, WTO and all, they rejected it, but still the debate is on. So similarly, the AI generated music lawsuits against AI models trained on copyright songs, that is without permission, and the debate is still on. And I really don't know where it will end, but probably the solution, we'll find a solution down the line in the future. The current trends is case studies of the AI impacting the IPR. What we have seen in the recent past is the significant influence, or impact of AI in the IP creation protection. The AI generated artworks, as I told you again, there's a lot of question about the copyright and ownership, but the created portrait was sold at auction, and they illustrating the complexity of attributing the creative rights to somebody who's not a human being. So there are a lot of legislative developments that are also parallelly going on, like the 2022 AI role in IP. The EU, that is European Union, has proposed some reforms in the IPR to address some of the issues related to AI generated content. So that is the first framework, law framework or legislative framework that has been developed, so that you to streamline the usage of AI and the usage of the content generated by the AI platforms. So, how does the industry respond to the AI, to the AI in IP? That is, a lot of organizations are now adopting the AI engines as such. Um, to maintain their IP portfolio, and because a lot of companies, a lot of organizations, they encourage the ideation from the employees, so it is very difficult for them to to manage the portfolio. So that's how they also started depending on the AI platform. For example, Sony recently started adopting a new AI platform where the employees can just put their idea, and based on keywords it will redirect the person's request to an expert in that field within the organization, within the Sony organization, so that they can talk to each other, take the experts help and advice, and start building up the idea from there on. So that's how they have seen that 25% hike, 25% raise in the number of patents that have been filed by Sony every year. Again, around the world, there are different jurisdictions. Each country operate their own legislative framework, But to start with, the countries like US and EU, they started harmonizing the laws concerning AI creations, and while the countries like China are already leading in integrating the AI within their, all the platforms, including IP. So there are parallel works going on. One side, the governments are trying to, put some legislative frameworks in place, and the other side, the technology group is trying to, invent new things in the AI domain itself. So ethically, yeah, as I told you, you should be well aware of how to use AI, and how the content generated by AI should be, how it is used. Again, in the creative fields, songs composed by AI, or the AI learning from the already composed songs, how does it work, and things you should be aware of. You should also be aware of that you are not really infringing somebody else's work. Because I mean, in the recent past, you would have seen our Prime Minister visiting France, where in one of the AI summit, he just addressed one of the major issues with the AI platforms of being biased. Even now, if you search in any prompt any AI engine to generate an image with a human being writing with left hand, it is very difficult for the AI to generate those images, because the AI engines are being biased out of the data that has been fed into them. So there could be hardly any image where a human being is writing with his left hand, and that's how the images are not aware of it. So for AI engines, humans always write with the right hand. So that's how it is right now. Srinivas, sir, you raised your hand. You want to say something? Okay. Responsible AI development practices. Yeah, that's another. Yeah, somebody has raised their hand. You have any questions? Able to hear me? Okay.
Yeah, I've just unmuted them, sir. Probably they can ask the question.
Hello.
Yeah, go ahead.
Hello. Yes, sir. Good morning.
Good morning.
Sir, I had questions regarding prompt engineering and image generation. So, coming to IP, can we use an logo generated by AI through prompt engineering for trademark registration?
Uh, See, the current laws actually in India, you don't have, as I told you, there's no legislative framework which will stop you using the images generated by AI. But whereas in US and Australia and EU, you are bound to specify down the image saying that this image is being generated by AI. So you have to make a, what do you call this, statement, or put a caption under the image saying that this image is generated using AI framework.
Okay,
But in
okay.
India,
Uh,
you're not, nobody is stopping you.
okay. So then, coming to that, would it be like first on first basis in India, like whoever registered the trademark, since prompt engineering works with in the form of decision tree, where both two similar prompts can generate the same or similar image. So in that case, the person
Exactly.
who registered for the trademark first will get his
Okay.
logo coin, or
Because you're bound to put a disclaimer down the image saying that this image is being generated by AI platform, you are most likely be rejected. Your trademark is most likely to be rejected. Point number one. Even if you are
okay,
granted, it is the sole discretion of the judicial system who should be given the trademark to. So as there is no current framework which will guide the judiciary system, so it is the sole discretion of the judge itself who's actually intervening or looking into your matter. So that decision will be the final decision. If you
okay,
compare
okay,
two images, one trademark versus the other trademark, and both the images are generated by AI. The first thing, the trademark will be rejected. Even if you are granted, then when you go to the court of law, it is the sole discretion of the judicial system. The
okay,
judge, in fact, is the one who can take the final call.
okay, okay. All right. Thank you so much, sir.
Thank you. Okay, I'm glad that you asked that question. So the initial assessment, the final module of this discussion. So how can AI? We know the fears and facts of using AI now. So how you should be using the AI? So there are some steps that you have to take care of. How before you actually use or depend on AI platforms for your ideation. So use any tools for due diligence, initial assessment, validate your idea on various aspects like how to commercialize it, how make it technically possible or not, etc. Other stuff. But make sure that you use special platforms where there are no traces of your questions or your queries, so that your ideation will never go out and made into public. So depend on the AI platforms only for the initial assessment, and check whether the similar idea or the idea is already existing somewhere. So disclosure in India. So what I suggest usually for most of the engineers who are into ideation state. So we usually get into NDA, sign some disclosure and non-disclosure forms, and people will start talking out, speaking out, discussing with the idea with us. So the first critical step in the IP protection is documenting the design itself, or the discussion, or the use cases you're trying to solve, the problem you're trying to solve, any technical specifications you have, and what could be the impact of that idea. So all these things you can gather the basic information from the AI engines, and you can use disclosure tools like Inspire IP, IPSS. There are a lot of tools which can help you out in disclosing your idea. From there you start once you disclose the idea, then you build your portfolio, and also you see the competitive advantages of management, who else is using the similar idea, and what use cases they are trying to cover, what features they have in the similar idea, how how similar is your idea with the existing ones, or how far it is. So these are some things that manually doing it might take some more time, or you miss or make some human errors in it. But AI can always be more efficient in it. As I told you, an example of Sony recently has started, building their IP portfolio using a AI engine, where it will redirect you or your request to an expert within the Sony, so that you can reach out to them, discuss the idea, and then finally take it forward. The confidentiality and privacy, security is always paramount in the IP management. You have to be very, very due diligent while you discuss, or make the idea public. So there are AI engines which will protect your personal data, and also make it public. So you have to be very, very clear, and it is not very safe to search for an idea, generate the claims, draft the patent, do the prior art searches, and then apply for the patent. So that's a very bad idea, I think, and I don't encourage the engineers to do that. Rather approach a patent. Sorry, approach a. Can you mute them? Okay. So you can always approach a patent engineer the way they'll just search, give you better results, and without actually making it public anywhere, linking it to the public anywhere. So yeah, that's all from my side. I am done. Any questions? The platform is open for questions if you have any.
Okay. Done. Raju garu.
Over to you. If there are any questions, you can always come back to me. I think Prem has raised his hand.
Okay, let me unmute them, sir.
Yeah.
So, good afternoon, sir. So, a very good session. So, you've gotten a lot of insights on AI into IP, especially. So, thank you so much for this. So, I'm Prem. I'm a patent agent in India and also a part qualified patent attorney in the UK. So, my question here is into AI on drafting patents, basically. So, we have about some 2 or 3 companies that is into the domain of patent drafting using AI.
Okay.
And we are also quite basically using their services for to some extent, and then again it comes into the basic, to the human hands for redrafting, for putting into a lot of points, claim charting, and all these things. So, what is your take on this? Do you recommend these companies to go forward at the current stage of development into AI, into patent drafting, or do you have any other insights on it?
Okay, as I told you, AI platforms, they come into 2 different categories. One, the AI being generally available, like ChatGPT is generally available. It is owned by one company, and it patches every day and night, and then you made it available publicly. There's another aspect of it is you own the AI engine. AI engine is within your organization limits, where it doesn't publish your data, take out the data to the out of the organization, or make it public. So whatever queries you write will be within the organization, or the data stays within the limits of the organization. There are a lot of frameworks available in the AI. In fact, lot of organizations like the one
Currently work for FI. We have our own ChatGPT
that runs within the limits of FI. So no data or no questions or content or images that has been generated will go out of FI. So if AI is being confined to if within the organization, you are happy to go and use it. There's no problem in it, because whatever lies whatever data is generated, that lies within the organization. So you don't have to be fearful of getting it out of public. So make sure that the AI engine that is currently you're using it stays within the organization. That is the best practice that one can do. but that also comes with a lot of cost if your organization is not in a position to spend that much. So better read the privacy laws of the privacy statements and laws that are published by the AI platform, and make sure that they publish saying that okay, whatever content is being generated for you will limit itself and will be within the organization, and that is not for the public consumption.
Wonderful, sir. Thank you. And also, this pops up another one question for me. So there are some free versions of ChatGPT or any LLM platform. Likewise, we have some premium versions as well. Is there a possibility that we can prompt the AI engine like ChatGPT or something to keep the information generated for this particular question to be confidential? And not use this particular data to be available for someone else to use it for further purposes, and not, maybe instructed to not use this particular data that we given or that it generates for the purposes for others.
Okay. ChatGPT currently uses every prompt that you give it to the ChatGPT engine. So it is public. There's no question of your question remains with you. So my question or my prompt will be in answer to somebody else prompt. So my responses for my prompt might be a question for another prompt for somebody else. So right now there is no thick line drawn between the user objects within the ChatGPT engine, because these engines are trying to gather as much data as possible and try to learn from it. So they are built for it. So they are built to consume data and then answer you. So you cannot stop it from doing so. Rather, what you can do is, as I told you, there are platforms like Grok, and like you can download and install within your system. And so these engines are specialized to scrape the internet, but doesn't publish your content outside your system. It will try to answer based on the content that is already available in the internet, but it will not take your prompt outside the system. You can depend on that, the micro LLMs that are available, which reside in your laptop, in your system. They don't go out. But yeah, as I told you, again, some engines are too huge, and some engines take a lot of CPUs. Doesn't fit in your local laptops, and it comes with cost.
Got it, sir. Got it. Thank you. Thank you very much.
Thank
you.
You.
It was very insightful, actually. Thank you.
Thank you, Prem. Okay.
Yeah, thank you.
So I am done.
Yeah, thank you so much, Vinay Garu. And before I end this particular session, I just wanted to highlight the fact that the previous question was also asked by Sri N. Zubenthung Nigili, Additional Deputy Commissioner for Nagin Mora, Government of Nagaland. So just wanted to acknowledge the fact that we are honored by all of your interest in this initiative on the occasion of World IP Day 2025, and we look forward to future collaborations that empower innovators across every corner of the country. So thank you so much for joining in, and thank you so much, Sri Vinay Kumar Thiruvaipeta sir, for this particular highly engaging and forward-thinking session. I think Ratna Kumari Ananta has got a question. You can unmute and speak, ma'am. You were given permission.
Yeah.
Ratna Kumari Ananta, ma'am, you have your hand raised, but if you have a question, please unmute and speak, or just drop a message in the chat. But again, thank you for your insights, sir, into this convergence of AI and IP law has been. And I also got to know yesterday that if there is a keyboard, there will be only one key in the future. The key will not be enter key. The key will not be escape key on the keyboard, but it's going to be only one key which says AI. if you just Google AI keyboard, I mean the key with the AI keyboard, you'll find the keyboard with just one key which says AI. It's I just wanted to add. It's a wonderful Google images which are there. I request everybody to explore that. That's how the future is going to be. We no longer will be having too many keys. That's on a lighter note, but we truly appreciate the way you translated complex technical issues, sir, and all the technical ideas which you put into practical takeaways for our audience. Thank you once again for being part of this webinar and for your valuable contribution to the World IP Day. Tanuj Kakkar, let me unmute. We have Tanuj.
Sir.
Yeah, please go ahead, sir.
Excuse. Yeah, thank you very much, Dr. Vivekanand Pattimani here. I have one query regarding commercialization of IP. We own IP with the 3 people, and some people are approaching us to get it licensed. So, how to evaluate the patent?
So there are multiple. Yeah, okay. There are multiple aspects of commercialization, sir. Two things is I'll discuss 2 things here. One thing is the real commercializations will come out of the real numbers that when you actually enter into market with your idea, what amount of potential that it has, and how much money it can generate. What is that your input? How much input you have to provide. So these things are calculated using some standard frameworks by any patent engineer. You can contact Eeva or so there are some experts who can actually help you out with the real commercializations. They getting license of it. License is actually purely a judicial thing or quasi judicial by your the domain or somebody is actually controlling the domain. If it is automobile, then you have a automobile section or the government body who actually give you license. If it is medical, there's a medical council for it where you have to get it licensed. If it is electronic device within the medical, then there are certain certifications that you need to approve or get it done, like CE and other stuff. So licensing itself has got multiple phases of it. So if it is electronic device, then you need to approach somebody for a certification. If it is within the medical thing, then that device need to be certified by some other organization, and then it has to be mass produced or used by a end user. So there are frameworks already existing, and there are regulators who are actually doing it. So you have to discuss with your patent engineer or some organization who are actually handling it, and they will guide you whom to approach and get it licensed. And for the commercializations, again, there are attorneys who will help you out, with the actual numbers. What is the value of the current idea?
Okay. Because already some 3-4 approaches, we thought we have to give a non-exclusive licensing to those 3 parties.
So
we can give non-exclusive. Okay.
It depends. So some of the ideas are very exclusive because it depends on the one who is actually consuming it. So the parties can actually make you give only exclusive rights or inclusive rights. So that is where so one party might give you some amount of X amount of of the production cost or the profits, or another organization can give you outright or lump sum amount. So it depends before you actually get into engaging many of these parties. First, you approach any engineer or patent engineer. They will actually give you the right value of your idea, because idea is very vague and you don't know what is the value of it, whether it is X amount, Y amount, or Z amount. That is where there are beautiful frameworks already laid in.
And that evaluation will be done by IPR attorney or somebody else?
Yes. IPR attorney. There are specialized people in IPR attorney itself who do purely commercialization.
Okay. Thank you very much.
Thank you, sir. Thank you.
Thank you, sir. And we also have Dr. Vivekanandaji and Ratna Kumari Ananta. If you have questions, please unmute and speak. Dr. Vivekanandaji, okay. You can just choose unmute.
Already I have spoken. Yeah.
Okay.
Just
Okay.
now I have asked the question. Thank you. Yeah.
Okay, thank you. I'll just remove the spotlight and so as we have the next speaker, let me just thank you once again, sir. So it is.
Hey, thanks for the opportunity.
Thank you so much, sir. So it is my pleasure to introduce Sri Vinay Kumar Povula, an accomplished IP attorney at Eeva Patent Services, with deep expertise in patent prosecution, enforcement, and strategic IP management. He brings with him rich experience in working with startups, innovators, MSMEs, and regularly contributes to awareness initiatives across various institutions. We look forward to his valuable insights on filing the best practices and enforcement mechanisms. Welcome, Sri Vinay Kumar. Thank you. Okay.
I think it's Vijay Kumar sir, actually from IPR Services, not Vinay Kumar.
Yeah, ma'am. Actually, Vijay sir told he will not be available until 12:20.
Okay.
So we brought him, but again, Vijay sir pinged us in the group.
I think I can take the session if you can make it live now.
Okay, sure, sir. So let me. I guess Vinay sir was here. Yeah, Vinay says video and audio. Please just give me one moment, sir. Vijay Kumar Garu. He was in the presenters space. Again, I see that he moved to. If you could raise your hand, sir, like Vinay Kumar Garu, if you could raise your hand, you'll be in the spotlight there. Okay, there you go. Yeah, I see that mic access. Yeah, sir. You both camera and mic access is available now.
Yes, sir.
Okay.
Audible?
Yes, sir. Audible. Thank you so much. And Vijay Kumar Garu, our apologies. I mean, as I thought first Vinay sir was in the spot.
That's fine. Let him complete and then I'll take
Sir,
up. No problem.
sir,
Go ahead.
I can wait for Mr. Vijay Kumar. No worry. Take the stage, sir. I can wait. I'm listening.
No. You go on as scheduled. Yeah, please go ahead.
Thank you. Thank you so much. Let me start my introduction with a small story before going into enforcement of IP or how IP is valuable to everyone. Some long time ago, when people were not habituated to communication channels and only letter writing was in place, there was a gentleman who approached the letter writer and told, I need to write a letter which should be confidential and the other person should only understand whom I'm addressing it to. So the letter writer adopted the same policy and he wrote a letter. Months later, the request from whom the request has come for letter writing, he came back, told that why hasn't a reply come? The letter writer simply put it in such a way, telling that the reply hasn't come because I haven't traveled there. The whole concept here is he has protected his writing skill and IP in such a way that he has to go there and he has to read it out again. So before, why I have took this story as a lead is enforcement of IP is my topic. Before enforcing comes into the picture, the protection should not be so stringent that enforcement itself becomes a question for the judicial authorities. As Sri Vinay Kumar Garu has before just told, there is no legal policy or something in place and the judges have to opt for it. And Prem Mr. Prem also has asked a question about AI and its influence. The enforcement of IP only comes into the place when the things are in a normal course and in an evolving phase. Then a stringent application process in place. That is one thing. And coming back to Dr. Bhima Reddy Garu, he was telling that while negotiating a contract, IP should be a part of the negotiation. Why I'm referring to that is, in terms of enforcing, that is a very crucial phrase he has introduced. In 1998, when Volkswagen was negotiating its operations to sell, to take over Rolls-Royce, they have paid 400 and so odd million pounds for taking over Rolls-Royce. Only little did they realize at the end of the negotiation and at the time of signing that the brand of Rolls-Royce was already sold to BMW. They were only taking the operations of automotive operations, but the brand itself is already sold to BMW. So the crucial part in the enforcement or implementing an IP portfolio management is to negotiate in crystal clear terms rather than vague terms or terms which are above a normal man's average intellect. Only then this can be in a proper format. And in such terms, in 1993, IBM should be considered as a pioneer in building the IP as a portfolio in itself. They always had a company which holds its IP value, and they do not deal with that IP portfolio only for the sake of dealing. They license the non-core technologies of IBM so that there's no conflict of interest with its core operations. That is the way to go forward. When it comes to India, IP audit is still in its very nascent phase. Most of the companies do not know what an IP audit is. Government should frame a policy. Gulshan Kumar ji is there. Through him, such people only can be recommending it to the government. It should be part of the procedure of filing your balance sheet, an IP audit, or your IP value should reflect in the balance sheet. IP audit should be incentivized directly or indirectly to make the companies that are coming up or startups to encourage IP audit in such a way that they promote the IP audit and brand and commercialize it in such a way that they create their own brand. Now, the policy framework is still not intact for India in terms of IP enforcement, because if you take an example of a small seed, what do you call plantation seeds of rice, maize, cotton, or example, etc. Bayer has such large unit in Hyderabad. After Arizona, this is the second largest in Hyderabad. But what they encounter mostly is when someone approaches a police station, the SHO of the police station files a 420 case because he is not still educated upon the IP value of the end result of what impact it has on the seed. He only files a 420 case or false selling of seeds under false name. Those are only the two cases that you would see. But the actual case doesn't stand in the court of law. The reason being, the case has to be filed under IP enforcement strategies, which is a very thin line in the framework policy as of today. And the courts are doing their best works to create a solid face of it. It's the liquid stage and it is still evolving. India has a lot more potential to do. If we have to do it as a country or as an Asian, one of Asian continent, which is into the service sector still, the framework and the policy should be adopted in such a way that we should even protect the trade secrets as good as the Western countries. Our trade secrets are not protected properly because someone has asked in the chat box also before whether some ancient scriptures, if they are written, can they be protected? And Ms. Divya has answered them. But what I see on a day-to-day basis is our trade secrets are always a knowledge that was sent by God or someone that we ourselves tell. We, in the sense, the Indian subcontinent tells. In that way, we lose the value of the trade secret itself. We attribute it to some external knowledge already without protecting the trade secret as Coca-Cola does it. Coca-Cola has also a trade formula, which is also used in Ayurveda or naturopathy here, but we attribute it to some ancient divine knowledge and we don't treat it as an original thought process. So these are the thin lines that we should tighten it up. We, in the sense, the policymakers should tighten it up, and the court should tighten it up to promote more of a service-based industry in India to an IP value or IP filing status in India. When it comes to the filing, I wanted to, not deviating from the track, I wanted to precisely tell, when you see the statistics of crime rate falling down, that doesn't mean the crime has fallen down in a particular country or a particular region. It means that the parameters that they have taken for that analysis, they have changed it. So the same thing with IP filings. China might be there, Korea, Japan, everyone might be doing a lot of IP filing. But what is the hit ratio of granting that IP? That is the whole realistic value that a country or a nation should take in more than IP filing. And in coming back to enforcement again, the more stringent enforcement norms a country has, the more protection that they provide to their IP filers or protection is granted, then we promote a certain atmosphere to file more IP there. But the enforcement itself is taking a long time, which is costing time and money. Then I don't think no one would be filing an original thought process in such countries where enforcement is not in place. And coming back to Kushanji, MSME is promoting in its own way to not to knowledge drain and granting some funds for original thoughts and promoting IP filings. Appreciate it, sir. And you have given me statistics of what happened last year and previous year. My request is the policy should be more in terms of IP enforcement. The time frame to enforce should come down with a marginal gap. Right now, to file a trademark enforcement right, it is taking 2 to 3 years, by which time the already infringer is making his own money. And the court cannot levy a fine for everyone. It might be 5,000, 10,000, 50,000, whatever. But by then, the damage is done, the infringement is done. My whole point is to cut short the litigation time. This is the environment today we are in, which is favoring the litigant more than the people who are holding the IP value. And as for the technology that is evolving and rapidly increasing in today's world, the idea has only the shelf life of a tomato. By the time the IP guy who comes out with an idea and starts protecting his idea, the infringers are already making money on that and closing their businesses overnight. So this type of things should be addressed by the government, and enforcement time frame should be shortened, and enforcement should be what you call educated more in terms of the people who has the power to do that. Like from the SHO level of a police station to a district judge or a high court judge, everyone should be educated on what the IP portfolio should be, how the IP audit should be in place for protecting the rights, and the enforcement should be in place. Give me a moment. And Dr. Bhima Reddy also has told that a student can have an IP, not only a corporate. That is a very good thought process. That is the atmosphere we have to promote, because only then the IP filings would increase along with enforcing it properly. And regarding negotiating laws, we are told. And Sri Vinay Garu has given a good input on AI and how it should be done by an individual or AI or ChatGPT or etc. But he is a good friend of mine. I can take the lenience and cite that he himself has copied from the Sistine Chapel of Michelangelo, the first image where the two fingers are touching. He has taken a lead out of it. So there's an infringement there also, Sri Vinay Garu. Okay. And Dr. Bhima Reddy Garu has spoken about the value of death. The value of death is where when the IPO owner, original thought owner, is trying to protect his IP, and where the infringers are already making their money and doing it. IP enforcement can only be done if IP audits are done properly and portfolios are reflected in the balance sheets. The classic example, what what mistake the policy framework people have done in our country is the Kingfisher brand. The Kingfisher brand itself is valued too high or too abnormally high, and overnight, one has devalued it in such a way that the brand has no nil value. So there is no loss actually to the brand creator in the whole scenario. The brand creator has made their money, they made their things and everything. But the whole process went on with the IPOs, and lame man who does not know and bought with the bandwagon of the news channels, the hype and the unhype of it. So to protect these, the IP policy should be framed in such a way that the enforcement time should always come down, and there should be a deadline to pass a judgment on when the litigant approaches the honorable courts or the authorities that are designated to penalize it. Or they should have a special boards. I do understand that high courts are overburdened with already the regular cases. They should have separate boards or separate arbitration centers. Arbitration should also come into IP portfolio, because that is the best way forward for corporates to enforce their rights in a faster way than giving the leeway for the litigants. I think I have covered more on the generalized aspects of the IP enforcement, and my advice is through this platform for the policy to be more stringent and favorable to the IP holder rather than too lenient and which is favoring the litigant. I completed my things on this. Anything on the enforcement side, people are free to ask, please.
Yeah, big thank you, sir. Thank you so much for sharing about the copyright infringement on a lighter note and wrapping up everything also. Okay, thank you so much, sir, for wrapping up all the great insights.
Hello, sir.
We have a quick question from Sankar Rao Ganta. Let me unmute the participant. And also on a lighter note, sharing the copyright infringement from our Vinay, sir. There is no escape. I mean, in the world of IP, in this world, there's no escape. So let me unmute the participant. One moment.
So I have a small question regarding the trade secret. There is no agreement between the parties.
Yeah, we can hear you, sir.
Can you hear me?
Yeah, we can hear.
So there is no agreement. Yeah, there is no proper agreement. There is no proper agreement between the parties about the trade secret. The trade secret is closed somewhere. So what kind of protection can the provider, trade secret provider, can avail in spite of the having there is no agreement between them? So how he get the protection?
Trade secret, when put into the form of agreement, is already revealed formula, sir. First thing, we are losing the rights there. Trade secret is only carried by certain group of individuals which are named in the agreement that these people have access to the trade formula, rather than putting the trade formula or trade secret into the agreement itself. Once it is written down into the form of agreement, it is no more a trade secret protection. Am I precise on that?
No, my question is that even within the core people there is no agreement. Within the core people there is no agreement. So what kind of protection the provider can get it? So for example, Coca-Cola, there are I think 3-4 people may have that formula.
Okay.
They don't have any agreement. One person out of those board or disclosed somewhere.
Yeah.
Or he himself practiced it. So what kind of remedies he can? So when agreement is there, then we know that there is kind of we can have a kind of litigation or something like that. So what kind of remedies he can get it without any agreements between them, if there is no agreement?
Sir, surely, sir, I am coming back to my answer again. If it is put in a form of agreement, it is no more a trade secret. And if there is no agreement and the person himself starts his own Coca-Cola type of business with the same formula, it is a highly impossible task. because referring to Coca-Cola, it is the best kept secret in the world, because if only 4 or 5 people sit together, they can have the entire formula. That is one thing. And if the trade secret is A plus B plus C, and it is revealed by everyone or one of the individual, and the entire formula is revealed and he starts his own manufacturing unit, no one can stop him, to be honest. No one can stop him.
Oh, thank you.
Thank you. Thank you, Vinay Garu. Thank you for that great question, Sankar Rao Ganta. And we'll also share all the speakers' contact numbers and email IDs so that you can also inbox them on LinkedIn or probably email them. And thank you so much, Sri Vinay Kumar Povla Garu, for your informative and practice-driven insights into IP filing and enforcement, and your guidance on navigating legal procedures and real-world challenges. This is like truly valuable for all our participants. We now move on to the next part of this session, and I'm pleased to invite Sri Vinay Kumar Makyam, founder of IWIN IP Services. I'm member of the District Consumer Disputes Redressal Commission, Sangareddy. He'll be sharing his perspective on enforcement strategies and IP management. Over to you, Vijay Kumar Makyam Garu. Thank you so much. So,
thank you for inviting me here for this online session. Thank you, Eeva, for providing me an opportunity to interact with the participants here. The topic given to me is IP enforcement. As Vinay said, there are some lacuna in the system, but the system has been developed. The rules and regulations around IP litigation are robust system that is very effective enforcement we have. We don't require any new rules and regulations to be in place. Okay. However, these rules and regulations, are you able to hear me?
Yeah, sorry to interrupt you, Vijay.
Everyone?
Yeah, Vijay sir,
yeah.
Maybe the microphone is a little choppy. The voice is cutting in and out. And could you also please switch on your camera? Probably you can have a change in microphone, or the voice is
sure,
cutting in and out.
Sure, maybe I'll do the yeah, I'll do the
yeah. In the meanwhile,
am I audible now?
Yes, sir. You're audible.
Am I audible now?
Yes, sir. You're audible.
And I have two systems. If you can see, one has a video and one has only the Ganpati image.
Okay, one moment. Let me just check.
I'll raise my hand on which video has.
Okay.
Is it clear now?
Yeah, Vijay Garu, you can go ahead.
Very good. So I was saying that the rules and regulations in IP litigation are robust, and they don't require any amendment as of now. The system is perfect. The only thing is we need to make people involved in the system to be learning the rules and regulations that have been framed. I'll give one example what happened with my professor who wrote a book on RTA Act, Right to Information Act. He has written a book way back in 2005. Right to Information Act has been enacted, and he wrote a book and he sent it to the publisher. After some time, he was invited for a seminar, and he prepared himself for. He was preparing himself for the seminar. He went to the library, picked out the latest book, and started reading it. He found that the author of that book, which he is reading, and what he has written is matching. Initially, he felt that it is the same thought process went into, but later on, once he scrolled the pages, he realized that it is the entire book is been copied, and he immediately went to the police station, nearby police station, with the book, and said that my book has been stolen. The person who's sitting in the police station laughed at him. You seem to be a mad professor. and you holding the book in your hand and saying that it is stolen. So he didn't understand the essence of the copyright law, and he had to speak with the superior officer, the circle inspector, the ACP, and the commissioner to make them understand what happened with his work. So that is how the police have treated him, and he couldn't able to lodge a complaint on the copyright infringement. See, that is what is required. The enforcement mechanism, the police personnel and courts and judges required to be made aware of what IP rights are. Because lastly, for almost till 2000, basically 2005, I think 1995 we signed TRIPS agreement till 2005. We have not bothered about protection and enforcement of intellectual property rights. Only when we have signed TRIPS agreement in 1995, we have invested our time and energies. Like government also promoted through various seminars and lecture series on IPR to different people. One thing is, we need to definitely focus on judiciary to learn about IP. Unless there are only few courts like Delhi High Court, Bombay High Court, Calcutta High Court who are dealing with IP litigations. However, the other courts, though they are getting IP litigation, they are not giving credence to it, and they are not resolving the dispute as it has to be resolved in an efficient manner. So for that purpose, I think all around the country, the judicial academies require to train judicial officers with intellectual property rights. Having said that, effective IP monetization happens only through licensing. And an alternate, if somebody is not taking your license and using your product, so that becomes a point for you to file a case, litigation. So litigation will be used as an alternate for licensing and monetizing the IP. So if you have an intellectual property protected to you and somebody is copying it without taking a license, then it comes the litigation. Then you need to file a suit in the court. So we have the action, the litigation action, what you take will deter the users of the intellectual property and make them to surrender to you for taking licenses and all, obtain licenses, the IP owner. Otherwise, they will not be deterred, and they will not. You make an invention, or you write a book, or you make a brand, they freely copy it if there is no deterrence of courts and punishment to them. So litigation is an option to monetize IPR in a better way if licensing is not working out. So when you litigate, either they'll stop it or take your license. Now, if you see the hierarchy of the courts in India, we have district courts, high courts, and supreme courts. So whatever district court says it is not final, you can appeal the matter to the high court, and whatever high court says it is not final, you can appeal to the supreme court, and once the Supreme Court gives the decision, that becomes a final verdict. So that is a hierarchy, that is a mechanism we have. And for all IP litigations, the start point is district court. It is not under the district court. There are several senior civil judges and junior civil judges. There are several types of judges are there. But then for intellectual property litigation, it is the start point is not senior court or junior court. It is a district court where you have to file the litigation. Apart from active civil litigation, we can also file infringement complaints in police station. If police is not, generally what we do is, like my professor did, the book he carried and said that it has been copied by somebody else, and try to file a complaint in the police station. Police station, if they don't understand, they don't take the case. Generally that is happens. The police want to shed off you, and they don't take your complaint. You need to register post to the station house officer the complaint if he is not accepting your complaint. Then approach the higher official, that is Assistant Commissioner of Police in urban areas. If it is rural areas, it is Deputy Superintendent of the DSP. You need to contact them and give your complaint again to them. If they also don't listen to you, then you escalate your complaint to Commissioner of Police in urban areas and Superintendent of Police in rural areas, and ask them to book your complaint. If these three people, that is Station House Officer, Assistant Commissioner of Police, and Commissioner of Police, are not acting on your complaint, that somebody else is copying and they are not acting and booking an FIR, then you need to go and approach first-class judicial magistrate as a private complaint. You need to file a petition before the magistrate and provide all information how your mark is protected, how and why police is not registering, how the other side has been copying, and why police is not registering your complaint. You explain that to the magistrate, and the magistrate will refer the matter to the police for booking an FIR and further investigation under 156 CRPC. So that is on the criminal side. Apart from civil and criminal, we also have IP issues, litigation issues with the trademark and patent controller, trademark registry and patent controller. If somebody applies similar trademark as yours in the trademark registry and the registry accept for registration, it is open for you to oppose. So that opposition proceedings, if somebody files a patented, if files a technology for patent and the technology is known for years together, you can file a pre-grant opposition. All those things will be taken up by the controller of patents and register of trademarks. So there is a procedure provided in the trademark and patent office also, where your oppositions will be taken into consideration, rectifications and revocation applications will be taken into consideration, and it deliberated and decided before the trademark registry or controller of patents. Once a decision is given by the controller of patent or trademark registrar, it is not final. You need to you can approve, you can file a review before them if you feel that they have not properly heard you or not properly understood you properly. Then you can file a review application before them. If the review also fails, you have an option to appeal before the High Court. Earlier it was Intellectual Property Appellate Board, but Intellectual Property Appellate Board has been abolished on April 2021, and since then the appeals have been transferred to the High Court. So now High Courts will take up the appeal, and in the High Courts it will be deliberated and decided whether your opposition should be successful or not. The trademark and controller of patents also give decisions of registration or refusal of your patent and all. On those decisions also you can appeal to the High Courts. So that is a procedure that has been established in the trademark registry also. Then as Vinay said, it is taking longer time in IP litigation. Once you file a case in the court, you would have invested hundreds of thousands of rupees or hundreds and thousands of crores of rupees in your project, and you invented some really good technology, and you want to do everybody's copying, and your project money is been at stake. So India, people were feared to invest amounts in India with the fear of litigation, which runs around 6 to 10 years or more than that. So Modi government felt that this fear need to be ended, and litigation in commercial transactions need to be reduced. That's the reason they have come up with Commercial Court Act in 2015. Commercial Court Act provides a specific timelines for settling the disputes, and it emphasizes that the dispute should be settled within 6 months time. However, commercial courts are also taking 1.5 years to settle the disputes, commercial disputes. So initially the commercial dispute was valued at 3 crores. Later on in 2018, it has been reduced to 3 lakhs. So even if your intellectual property dispute, which is worth less than which is around 3 lakhs, you can file a suit in the commercial court. So commercial court, the moment you file a suit, within 120 days, the judge has to pass an within 120 days, the opposite party has to file a written statement providing his defense and all. If he is not able to file within 120 days his defense, the suit he'll lose his chance to file written version. Thereafter, the case diary management will be given. The court will decide on which day you need to file evidence, on which day the opposite side, the defendant need to file his evidence, and when you need to provide your arguments, and when the opposite side need to provide their argument. Everything will be clear. Case diary management will be given, and based on the diary management, it will go on. And within as of today, it is 1.5 years to 2 years or max 3 years. The suit will be decided. Litigation suit will be decided. All intellectual property matters are considered to be commercial suit, and commercial court has the jurisdiction to try the suits. And commercial court has one interesting aspect. If you are not claiming for urgent interim reliefs, the commercial court suggests you to go for pre-mediation. Even before commencing the court proceedings, you talk to the people. Sometimes it is ego. The marks are similar, but the ego of the party, the person who copied, will not make him accept that it is a copied thing. So when you do a mediation, maybe he'll realize the mistake and he'll give up fighting the case. So pre-mediation is one aspect that has been included in Commercial Courts Act, which makes it mandatory for parties to pre-mediate before coming into the litigation. So pre-mediation is under Section 12A of the Commercial Court Act. It is mandatory, and you need to go for mediation. So likewise, we have several alternate dispute resolutions, especially if you name disputes. If you have a domain name dispute, WIPO under UDRP policy, Uniform Domain Name Resolution Policy, mandates arbitration mandatory, and WIPO arbitration is functioning very well, that they are taking up all the domain name issues and transferring the domain names of registered trademarks to the owners of the registered trademark if it is if the person who has copied has no legal right to use that domain name. Apart from that, in India also, MIXI under the Ministry of Information Technology, for .in.com trademarks, it is WIPO, and .in trademarks, it is MIXI who handles the arbitration, and they they deliberate the arbitration, they send the complaint copy to the other side and hear the other side and finally decide the matters. So courts, there are various types of injunctions. When you file a litigation, there are various types of injunctions that are available. When you file a suit, to decide the suit, I said it will take, even in commercial court, it will take 2 to 3 years. For regular courts, it takes about 10 years, 12 years. So to avoid, until then, if person is doing business in the market, it will be denting your, it will dilute your IP rights. If there's a trademark, it will make, there are several sources for same trademark, so it will become dilution in the market. So to avoid that, we can file multiple interim applications in the same suit, in the same complaint what you file with the district court. You can ask for an urgent interim reliefs. Interim reliefs kind of Mareva injunctions. Mareva injunction is stop him prima facie, I am the owner of the IP, I have been registered IP, stop him from marketing the product or manufacturing the product is what we'll ask under Mareva injunction. Patent pillar order is another kind of injunction order where search and seizure, if you believe that defendant at one particular place has kept the goods which are infringing, you can seek for this patent pillar order under Order 26 of CPC and ask the courts to appoint a court commissioner to visit the defendant premises and search and seize the products which are infringing. And then there are various other injunction orders. More importantly, I would like to discuss on John Doe orders. John Doe orders are those orders, if you don't know who is copying, but in the market there are several products coming in, then you can take it for the entire territory. Say for example, entire Andhra, entire Hyderabad. I want an injunction order, nobody should sell the product similar to mine. So that kind of order you can obtain as John Doe orders. So these are the various types of orders that are available for a litigant to enforce its rights. Apart from that, recently we know there are certain standards have been set for technologies, and say for example 5G system, for mobile communication system, 5G system. 5G is patented by Ericsson. So India has made a standard that only 5G technologies should be introduced, not lower than 5G technologies should be introduced in the market. So the standard has been set by Indian Standard Setting Organization. So if somebody else want to come, since the patent is already with Ericsson, they have to invariably take license. And if Ericsson doesn't like a particular organization, and if they charge more, if they want to eliminate that particular organization, they'll quote higher license fee. That will not be allowed. Standard essential patents, patents which are set as standards, the licensing need to be done under a system called FRAND, F-R-A-N-D, fair, reasonable and non-discriminative system, where the price, the licensing fee should be uniform to everyone. It should not be discriminative person to person or organization to organization. Everyone should have the same licensing fee. So that is been decided, that is been made a norm for licensing the standard essential patents. Apart from this, I would like to close my talk today by saying that, see, MSMEs, see, large organizations, anyways, they can sustain the litigation costs and timelines, everything. But if it is a small entity, small MSME organization, for them, if there is a litigation and the lawyer asks 5 lakhs, 6 lakhs as a litigation fee, he can't afford, he rather gives up. So most of the MSMEs have seen that instead of fighting with mighty giants, they have, even if it is their own trademark, or even if it is their own technology, they tend to give up because of the fear of the cost of litigation. So what I suggest is, in India, we don't have IP insurance. Till date, we haven't come up with litigation insurance, or IP insurance has been created in India. I wish India should adopt some litigation insurances sooner or later. However, for combating IP litigation, MSMEs can form an association and pool up their monies. Say, for example, Hyderabad cluster has 100 industries. 100 industries, each one of them every month 1,000 rupees. If they keep, it will become 100 into 1,000, 1 lakh rupees per month. And if it is 4-5 months, it is 6 lakhs easily. And I'm sure that within 4-5 months, you won't get any litigation. When a litigation comes up, that fund will be available for you to fight out. Instead of giving up, you have a muzzle to fight the giants who. There is a saying for trademarks, it is trademark bully. You want to stop somebody from entering into the market whose product is moving faster, you bully him with the trademark litigation. So that kind of frivolous litigations have been coming up, and you need to fight out these litigations. And courts, generally, they won't even look into the moment they show some registration certificate, court feel that they are the owner of the IP, they will not even listen to you. They'll give ex parte orders against you, and to vacate an ex parte order, it will take about 1-2 years time. By then your market will be crashed. So it is important for you to ensure you are properly represented in the courts with proper litigation support, for which huge amounts are incurred. You should ensure that that pool of amount is available to you. And lastly, I said that IP is two-way sword. You respect IP of others, others will respect your IP. So whenever you are introducing a new product into the market, ensure freedom to operate analysis has been done. Check if there is any similar trademark already registered for that product. If there is a similar trademark registered, adopt a new mark. Don't use the same mark. People are saying that no, wo aayega to dekh lenge. If he files litigation, then we'll check it out. That kind of attitude need to be removed. You need to thoroughly check, and if there is something similar existing, avoid adopting the trademark, adopt a new one. If some technology is already patented, don't wait for the technology to expire. And then after 20 years, you're free to copy it. Nobody asks you license fee. So that's how you need to do it. And on internet, not everything is free. You download something, keep it in your work. It's not perfect. You need to seek license whenever you want to adopt some work which is available on internet. The person who posted it on internet, you need to ask permission from him. If he permits, well and good. If he doesn't permit, you should not use it. With this, I thank again the organizers, Nimsmi and Eeva, for giving me this opportunity to interact with you all. I'm open for the questions.
Yeah, thank you so much, sir.
I think lastly, the previous question, somebody asked, how can I enforce trade secrets? Trade secrets are enforced in 3 ways. One is under law of torts. You don't require any agreement between the parties. If you see, for example, you have given information to your master or your wife, for example, and she breached the trust. You had a trust on her and given the information, confidential information to her to keep it safe. But she revealed in the market. So she has breached your trust. So you can file a suit of breach of trust under law of torts. And then secondly, if somebody steals your idea, you kept in your drawer or your bank locker or whatever, wherever it is, very securely, but somebody breaches your security, enters into your premises and steals the data. So what he did here is stealing the data. When he has when he stole the data, it is theft. Theft is punishable under Indian Penal Code now. BNS, the theft will be handled there. And thirdly, contracts. Contract between one party other party. The NDA or non-disclosure agreement or material transfer agreement, whatever you are drafting, it need to say what information you are sharing and how it need to be protected. The agreement will be between both of you, not any third party will have access to that agreement. So only between you it will be there. So what information you are sharing and how we need to deal with. In case there is some leakage, what he need to do, all that will be written, and some liquidated damages will be written in the agreement. If he breaches that agreement, then you can file a suit for the trademark, trade secret misappropriation. So all employment agreements and other NDAs will come into picture. If somebody breaches those agreements, you can file a suit and recover liquidated damages. If there is no agreements, as I said, IPC and law of torts will help you in enforcing rights. Yes, sir.
Thank you so much, sir. Vijay Kumar Makyam garu. So if anybody has any more questions, probably please drop it in the chat. And also for all the registered participants, we'll make sure that you get the speakers' LinkedIn profiles so you can directly DM them, direct message them, and also you can drop them an email. We'll make sure that you get their individual email IDs as well. So big thank you, sir, once again, Sri Vijay Kumar Makyam, for this comprehensive session on IP enforcement. Your rich legal experience and practical examples have given our participants a deeper understanding of enforcement mechanisms and procedural clarity. So we are truly grateful for your contribution, sir. And now it's my pleasure to invite Sri Anugu Vijayabhaskar Reddy garu, IP attorney and founder of Roots IP Services. That's where the strong roots of whatever the knowledge which I have under IPR also comes from. While designing the visuals, graphics, I was like, where should I put the Roots logo? And it gave me a little confusion there, but thank you so much, sir, for being here and blessing us to speak on this building an IP portfolio for startups and MSMEs. Sri Anugu Vijayabhaskar Reddy garu is known for his grassroots in the level of IP work, not only in Telangana or Telugu states like Andhra, throughout India, and his strategic guidance for emerging businesses, lots of T-Hub startups. There are so many examples. Over to you, Sri Vijayabhaskar Reddy garu. Thank you.
Thank you. Thank you, Raj. Welcome to all the participants. At the outset, I thank the management of NIMSME and Raj, you and the Eeva team for making wonderful efforts for this session. Yeah. Today's topic given to me is building an IP startups and MSMEs. So let me share the screen so that we go slide by slide. So let me present the screen. So can you make me as a presenter? Then I think then only I can share my.
You're listed as presenter, sir. I mean, there's a button which says share. It's quite tricky there. It's right next to end event.
Yeah, share. Yeah, share.
Click
Yeah.
on share. Again, hit share by sharing screen or that particular window.
Share content only. Share stand.
You can share the entire screen, which is absolutely fine. The UI of Microsoft Teams is a little tricky. If somebody accidentally clicks, there you go, sir. We see.
So are you able to view my screen?
Yes, sir. We can see it. Probably you can make it full screen, sir.
Yeah.
Like the way Swapna ma'am did.
Let me make it.
You can click on.
Yes, right.
Yeah, we can see all the slides. You can just click on view and full screen, or you can continue this way. Thank you.
Yeah, I'll continue. So if there is any problem, let me know. So this webinar is main thing is that on 26th of April we celebrate World IP Day on this occasion. So we like to bring IPR awareness to the participants, and WIPO is the organization at the international level, World Intellectual Property Organization. So that looks after the IP events around the world. Yeah. So so on this World IP Day, so the theme is feel the beat of IP. So it's mainly related to uh, mainly copyrights and other intellectual property rights. Yes. Coming to the current thing. So why IP matters for startups and MSMEs? So we had to see that, okay, apart from money, so many startups or MSMEs think that money is the only thing. But so these IPs, so generally intellectual property rights, so they come under the category of intangible assets, like lands, buildings, and other assets. They fall under tangible assets. So that means we can touch, we can feel, and everything. So these intangible assets are very, very important for the small scale industries or startups or MSMEs. Why? Because when we compare with established companies or the big giants, like whatever you call Fortune 50 companies, Fortune 100 companies, I do not name the particular companies, but these startup companies, they have limited resources when compared to these companies, established companies. But if you want to start a business, we need to have assets. So mainly for startups and MSMEs, so these IPRs are very, very important, often which are very neglect. So many MSMEs, they neglect. So whenever it comes, we will file a trademark. Whenever we see the threat, then only will file a patent or copyright. But they do not see it as an asset. So once you lose it as an asset, then it will be very difficult. So once your asset becomes a public knowledge, then it will be very difficult to you to protect, because everyone is using that one, everyone is commercializing that one, everyone is familiar with that one, and there is no distinctiveness, there is no novelty in that one. So once it becomes a public knowledge, so at that point of time, it will be very difficult for you. So even though there are any cash problems or any kind of limitations, so it is very, very important for startups and MSMEs to protect the IPRs. Why? Because these are real assets that will help you, because earlier speakers have also told that importance and valuation and about other things. So without IP, it will be very difficult for any valuator to assess the value of the company. So yeah. And the second point is enhances valuation and investor interest. Yes, we have seen, and builds a brand and market dominance. So how can you establish? So if you want to compete with established players, so it is only because of the IPRs, registered IPRs or the pending IPRs. So if you look at IPRs, first it will be in the pending stage. It could be the patent, trademark, copyright, or designs. It takes some time. So therefore, think in advance and then be ready with the registration certificates so that you can enter the market with immediately. So that means the pending application will not give you the proper rights. It is a registered certificate, like registered or the granted patent, registered trademark, registered copyright, registered design.
Yeah.
So these will
Bhaskar
give you
Reddy,
the
sir.
rights to.
Yeah, sorry
Sir.
to interrupt you, sir. Could you please share it again? Okay, now we see the screen. Yeah, thank you. It was frozen.
Yeah.
I mean, we could see only the white screen, but yeah, thank you, sir. Please continue.
Yeah, now IP types are relevant for startups and MSMEs. So here, if you look at the prominent rights are the patents, copyrights, designs, trademarks, and trade secrets. And there are governing laws. And even we had many questions regarding the trade secrets. Earlier speakers, they have explained it. So it is very important for you look what falls under different types of categories and how to protect them. Sometimes if the solution or the system is very big, it can come under multiple aspects of IP. Maybe it could come under patents as well as copyrights as well as under the designs if it is related something. So even it may come under trade secrets as well. So we have to see. So we have to bifurcate, we have to bucketize or categorize systematically, okay, what has to go in the patents, what has to go in the copyrights, designs similarly. And if there is any confidential information, maybe it is time to protect as a trade secrets, how like earlier speakers we have spoken about the Coca-Cola formulation and other things. So it is very important to note that in the patents we have to disclose everything. So we have to disclose everything, then only we get a right to for our invention. If you do not disclose, then we do not get a patent. When we do not get a patent protection. But in the case of trade secrets, what happens is we should not disclose anything to protect. So we should not disclose, then only we can protect it. So these are two opposite sides of protection. So in the patent, we are disclosing everything. We are telling everything, including embodiments, examples, description, claims, everything to the patent office. And in return, the patent office is giving the rights so that we can stop anyone for a particular period of time. The maximum period is 20 years. Whereas in the trade secrets, by keeping it as a secret, so you are enjoying that right under the common law, so for an indefinite period of time. So when it is, so why do we go? So we have to see, so okay, whether this product composition or system is going to be updated very soon, or is it going to sustain for more than 20 years, 30 years, 40 years, or 100 years. Then if you think that my system, my product, my composition has a validity of more than 20 years or 30 years, then we have to think of trade secrets as an option, especially pharmaceutical compositions and the business information. So, or the business model of big companies. So generally they do not file a patent, especially if you look at the Coca-Cola one. So they have kept it as a trade secret. Are they filing patents? Yes, they are filing patents. Are they filing copyrights? They are also filing copyrights. Are they filing trademarks and designs? Yes, they are filing, but for something else, not for the core formulation. So here we have to, this is the best example where we have to bifurcate as which one has to be protected under what types of IP. Yeah. So now coming to the IP support for MSMEs. So this NIMSME and the MSME DI from Balanagar, so and other, even the central government under the SIPP scheme, Startup India scheme, so they are helping out the respective entities, either it could be startups or the MSME entities. So they are eligible to get the protection, and even Gulshan Garu has also explained about the support, and even AICT, they are also giving some kind of support. So that means there are various channels for the MSMEs. Only thing is they need to identify whether to see whether we are eligible for that one or not. If they are eligible, yes, they can utilize that one. And if you look at the NIMSME scheme, so there are various schemes that even if you support, even if you have an invention disclosure, NIMSME, if you think that it is eligible under IPR scheme, so there are various vendors or facilitators listed under NIMSME who will take you to the next level. They help in conducting patent search, they help in conducting patent drafting and filing, and even including trademarks and design. So that means only thing is the entity has to pay the government fee. So provided thing is that yes, that MSME entity has to be eligible. So for every scheme there is eligibility criteria. If your MSME is eligible under particular criteria, you can definitely take help. And most of the schemes, the professional fee is waived off. So that means that agency or the central government or the patent office will pay the patent agents or the facilitators who are helping you. Yeah. So in the course of building a strategic IP portfolio, so that means there are various steps. So early steps, so that means identification of IP. So how do you identify IP? Maybe from your research and development, maybe from your branding, maybe from the product design stage. That means, so this identification of IP has to occur much before you commercialize, you prototype or things, because then only your IP will be ready. So once you start identifying IP at the launch of your product, then it will be very difficult for you to protect it by the time, because the flyers have gone out, the marketing team has already put your information on the Facebook, LinkedIn, or some other places, or maybe on your own blog. So that means it is very important. That means first to identify, then you prioritize what has to be filed, whether patents are important for you, trademarks are important for you, designs are important for you, because funding is also a problem. So we have to see, okay, how many patents, how many trademarks, how many designs, how many copyrights. So how your portfolio has to look alike. So that means it's not with one or two patents you want to satisfy. You have to have a a very good number. So that means especially if you are if you want to grow up with, or if you are looking for a kind of investments, so definitely the granted rights will play a more important role than the pending rights. And file early to protect. So this is what I want to tell you is that, so that means if it is protected, you can take action against the infringers very easily, especially for trademarks. So nowadays, earlier we used to get the trademark examination report within 1 month, but now it's taking 8 to 9 months. And again, after that, you have 4 months of time to get the trademark certificate. So that means ultimately it takes about 1 year to get a trademark registration. And similarly, if you want to take about to get a patent right, it easily takes about 2 years or something more. If you have this ASIPP certificate, and if you go for early publication and early examination, then there is a chance for about 1 to 2 years that you will get. So that means you have to keep that lag in mind before launching any product. Okay, so that means you have to plan early for filing. So do not wait till the last moment. Maintain and monitor. So once you get these IP, so it is very important to look into the renewals. If you look at the patents, getting a patent is not important, but so Mr. Vinay and Vijay Kumar Makkyangaru, they were also talking about enforcement. So when you can enforce? Only when your IP right is valid. So when your IP right is valid, so when you pay the renewal fee, especially for patents, from 3rd year onwards, you have to pay the renewal fee, whereas it is much longer time for 10 years for trademarks and design. So that means, so especially when you are into patent, when the patent is granted, if it is in 3rd year or 4th year, so that means within the period of 3 months, so you have to pay the pending renewal fee. Yeah, so this is very, very important if you are a patent owner. And leveraging IP. So that means I'm a small player. So how can I develop by using this one? So that means like earlier speakers told, like licensing, collaboration, and funding. So that means if you are not in a position to commercialize your inventions, then how can you do that one? Licensing. So how can you get a licensee? So if you are giving a license, you are called as a licensor, and the person who takes the license is licensee. But how can you get it? Who is going to take? So that means your inventions or your trademarks should be such catchy. If your invention is solving a real-time problem that is not solved by anyone, and if you are having the right, so that means patent is a right, and if you are a patent on that one, so definitely you can easily contact them, easily contact various big players, and there are certain licensing rates maybe at the rate of 4%, 5%, something. In the high-tech domains, it is about more than 10% as a license fee or the royalty fees. So that means, so even in the licensing, so we have various types. So that is like a exclusive and a non-exclusive license. So you can think it. So once, like always, I tell that your IPRs are assets. So you have to use those assets to get amount, to get profit, to get funding, to meet your needs. But if you're not using that one, then it becomes a liability. So that means in turn, you have to pay the attorney fee, you have to pay the renewal fee, you have to respond to so many notices. So that means, so how you are taking it forward, as in a positive way, so to get revenues, or only to defend it, or maybe for the namesake. So that means you have to be very aggressive in leveraging your IP, then only you will be successful. So there are certain players, and the challenges are mainly for the MSMEs are lack of awareness, limited budget, and legal complexity. So many times, even if we get a small notice, so we'll be afraid and we do not know whom to approach. So many times, if you are into patents or trademarks, so then there is a possibility that you'll be getting many legal notices saying that you're using a similar name of mine, or you are using a similar technology of mine. So they will give a big notice, and even you have to write an undertaking to saying that I will not use the technology, or I will not use this particular name. So therefore it is very, so these are some of the challenges. So how you can overcome? You're reaching the right people, reaching the institutions like NIMSME, reaching the IP hubs, T-Hub, or maybe IP incubators surrounding you. So it is very important for you to identify these kind of government institutions which provide a good knowledge distribution to anyone who approaches them. Or there are with IPR facilitators, especially if it is related to patents or trademarks, you can approach IPR facilitators. And The next thing is focus on scalable and enforceable IP. So do not file a patent which is not enforceable. You try to define the boundaries well. So it should not be very small. It should not be very big. Okay. What is the solution? How you are going to develop a product, and whether that different examples are described in that one or not, so that if anyone copies, you can take the example. Let's see, you see at example 5, I have clearly explained about my invention, how it is going to work, and you have clearly copied that example 5. Maybe example 1, 2, 3 or embodiments we call in technical language. So those has to be described well. So then only you can protect it. So if you look at some of the case studies, yeah, so there are certain successful companies like Boat already we are looking into. If you look at, like, if you open any Amazon or somewhere, so definitely these Boat is the name that comes for any electronic products or something. So it is a new company, so that has established success. Let's see in the following slides. And other two companies are Nuka Robotics, Chakra Innovations. So I have taken few examples. Is like these are also small companies, but they have become big, very big. And now they are like as if it is a multinational company board, because if you look at a headset or any kind of electronic components, why? So why they have become successful is, so they had followed that IPR strategy in a very big way, particular way, perfect way. Like the company, so Imagine Market Private Limited. So it was established in the year 2016. So they are into consumer electronics and direct to customers on mainly through Amazon, Flipkart or somewhere. So directly they are selling it. So what is their IP strategy is brand credibility. So that means even if there is any kind of replacement problem, any kind of support the customer needs, so we should be in a position to give it, in whether it could be sometimes it be costly for you to replace that one. So but once you establish that brand credibility, you can compete with the established player. It could be Apple, Samsung or whoever it is, but your pricing is very cheap when compared to those particular expensive brands, and the credibility is good, the service is good, the working is good. So and there is no fake goods or infringed goods. So you are taking enough measures. So then it will be easy for the customers to treat you as an established brand. And securing design uniqueness. So what I have learned is that they have filed many design patents. So like if you look at a headset shape or maybe the earplugs, earbud, whatever the technical name you call, so they are trying to get the protection for the shape, so that that's because sometimes if you look at the electronic devices, the shape of that ear headset, ear plug is also very important. So they are securing the design rights, and they are also preventing counterfeits. Why? So once you have this IP with you, so you need to see who are infringing. It could be on social media, it could be on your marketing teams or sales teams. If they find out anything, so are they really their own technology, or depending on your technology, or copying your technology and use it as their own, and boosting valuation for funding. So that means if you have the enough IP, you can project, you can have the roadmap. Okay, so for the first 5 years, so these are our products and things. So maybe in the next 5 years, we are going to do like this, or maybe couple of first 2 years, our roadmap is this one. And once we are successful, we are going to enter into these markets. And if you have a very clear-cut roadmap, and if you do not achieve, maybe we'll go into this way. So yes and no, because we cannot be successful in all the things. At least we should have, okay, if I am successful, maybe I'll go to this one. If I'm not successful, maybe I'll try to improve the defects or the faults in it, and I'll come up with a new product or the improved product. So yes, so this is also one other company, Nuka Robotics. So this was founded in 2017. This became famous during the COVID-19. So they have developed various products, especially during the COVID, especially into robotics and things, medical ventilators. So they have become very good. They have acquired very good name during the COVID-19. Yeah. So the key takeaways are, so this is an asset. So always, so Mr. Vinegar was also telling that we should have IP audit and stuff. Then only we'll come to know whether we are getting any revenues out of our IPs, or maybe still we are pumping it to and considering as a liability. Yeah. So early IP protection can boost valuation and competitiveness, and so use government initiatives and regularly audit. Yeah. Yes, so this is all from my side, and I think, yeah, so around 1:20. Yeah, so we are on time. Yeah, so let me stop sharing, and the forum is open for the questions.
Yeah, thank you so much, Vijay Bhaskar Reddy Garu. So if any of the participants has got question, please drop them in the chat. Just give it a minute or two.
Yes, yes, sir. Even I am putting my email ID so that they can email ID. They can email me. Yeah, so maybe, so if they do not have questions, and maybe we'll go for next round. Maybe I think, yeah. So
Yes.
thank you all.
Thank you, sir. And we have. Thank you so much, sir. Yeah.
Raj, you are on mute.
Yeah. Thank you so much, sir.
Yeah.
Thank you, Srinivas Garu. And we do have the little, I mean, it's a 33-minute video, but we played like 20 minutes of Veena Pani Garu. Probably Swapna ma'am, if she allows, we can play the rest of it. Or you can
Yeah, you can play it.
Yeah, and over to you, Srinivas, sir. I mean, if you'd like to add in any insights for all the interest, I mean, anything in IPR, if it excites me, it's only the energy of Srinivas sir, Srinivas Mathipati garu. Been doing it for over a decade, but still, it took me a couple of years to understand what is patent, what is copyrights, what is trademarks. So I just filed my trademark application probably a month ago after understanding it for over a decade. But thank you, Swapna ma'am. So Srinivas sir, probably you can share a few insights or anything we'd like to add as I bring the video on the screen.
Thank you, Raj. First of all, respected speakers, distinguished participants, and organizing partners. So, on behalf of NMSME, I'm honored to host today's insightful webinar on IPR and commercialization. So, held in celebration of World Intellectual Property Day 2025, we thought of actually doing it a full day workshop, physical workshop on 26th itself, due to some unavoidable things. So we had to actually do it as a webinar. But in future, in collaboration with NMSME, Swapna ma'am, we had a plan to roll out monthly and quarterly webinars as well workshops. So we'll be coming up with a schedule of it. So over the past few hours, we have explored a diverse range of topics, from the fundamentals of IPR, shared by Sri Divya Sridharan from Chennai. She works for us, but she is a freelancer. She is a patent agent doing it for us from last 10 years. So she shared practical aspects of kinds of IPs and the kinds of filings and all. Later, like our speakers, including Vijay Kumar Makiam sir and Vijay Bhaskar Reddy, they shared the enforcement part of it and commercialization of IPs, kind of different licensing formalities existing. And the rising role of AI in IP protection, or maybe the use of AI in creating IPs by Sri Vinay Kumar Tirvaipeta. So we have two Vinay Kumars and Vijay Kumar. Like it's a confusion while we are pronouncing the name. Sorry for that. So each speaker brought a wealth of experience and practical insights that would surely empower our entrepreneurs, innovators, startups, and MSMEs. Not the least, we have to thank MSME Development Office, Hyderabad, NMSME, the whole team, the management, Srimati Swapna Vanamala Garu for opening the session with a strong foundation. And it's all her initiative, actually. Thanks for her to giving us this opportunity to co-host along with NIMSME. Sri Gulshan Singh Bist for emphasizing policy direction for MSMEs. Again, Dr. Bhima Reddy Garu for showcasing government support and funding avenues for institutions in particular as well. It can be startups or maybe MSMEs coming up with new ventures, innovative startups. And there were questions from participants on use of AI tools in relation to IPs, and our speaker Sri Vinay Kumar clarified that AI tools like ChatGPT can be legally used to assist in drafting or maybe creating some work thought from the inventor or the author, but they can create some work taking assistance from AI tools, both in India and globally, for formatting, maybe structuring, for generating some drawings, or maybe validating some results in case of pharmaceuticals or maybe biomedical or biotechnology fields. So they are knowing about the testing standards in any other field in engineering. So to know before publishing or before filing a patent application, to know what type of tests need to be or required for a particular kind of a product which is of new origin. But critically, Sri Vinay Kumar opined that a legal validation for the claims of the inventor step or the other compliance related matter of patent filing, trademark filing and prosecution and copyrights, which needs an IP professional's help. So this need to be noted by the inventors and all the participants today. So he also made an important point that internationally only natural persons are recognized as inventors. So AI cannot be named as one. So I think we all know there is a case or maybe there is an issue. A person or inventor, actually a company naming AI as an inventor. So in UK. And one more important thing to note is that AI tools like ChatGPT does not store or data for training or regenerative training or whatever the tool is trained with. So the users can control data privacy settings while they are using ChatGPT. I'm not sure the free use of ChatGPT or the paid use of ChatGPT has these settings thing. Obviously, the paid use of ChatGPT should have had this privacy setting. So inventors are advised to avoid entering unpublished sensitive details unless privacy settings are securely configured. And there was a question on how to enforce trade secrets. Our speaker, Sri Vijay Kumar Makim and Sri Vinay Kumar
Sri
Pugula
Maha Saraswati
clarified on ways to enforce the trade secrets. The question was about the kind of a formulation of Coca-Cola or a similar formulation. Sri Vijay Kumar Makim also made a critical need or the current need for training the ecosystem in terms of reducing the delays in IP enforcement. So, and a special note of gratitude to, again, MSME Development and Facilitation Office, Hyderabad, NIMSME and the Indian Specific Intellectual Property Facilitation Center at NIMSME, Roots IP Services, Ivan IP Services, and Eeva Patent Services for co-hosting this event and continuously supporting the IP ecosystem. To all the participants, thank you for your enthusiasm, curiosity, and active engagement. So we have almost 100 plus participants, and we have at the end of the session also, after 4 hours, actually we have 70 plus participants still hanging there. We are very thankful to you. On this World IP Day, let us reaffirm our commitment to protecting innovation, nurturing, transforming ideas into value. We hope this session has inspired you to take the next steps in your IP journey with awareness, action, and ambition. Tune into more insightful webinars and capacity building sessions from NIMSME, IPFC in particular, organized in collaboration with leading IP attorneys and firms associated with it. Let's continue fostering innovation, awareness, and IP empowerment across India. Wishing you all continued success and innovation. Thank you. Jai Hind. Over to Swapna ma'am for your comments. And then after that, like Raj can actually share our today's guest speaker's video bite, because we thought of actually having him live, but he has a medical emergency. Yesterday night we had to request him for a video. He actually he gave a very good video, but most of the content is in Telugu. But yeah, I wish like our attendees, participants are also maybe 70% are from both the states, but we have very few special registrants as well. So one Raj mentioned, like one from government of Nagaland. So he's an officer rank. So he was heading the capacity building activities in state of Nagaland. He was asking a question earlier in the session, and we have other distinguished participants from different parts of the country also. Thank you very much. So thank you all. Jai Hind. Over to you, ma'am. Swapna ma'am. Thank you.
Thank you, Srinivas Garu. Thank you on behalf of NIMSME once again for being the part in this webinar. And I also thank all the participants for showing the interest and staying with us in this particular webinar and gaining insightful sessions. We had a very insightful sessions by many speakers, actually, who have given a practical insights. And there was a session on AI also, which is very much required now because everything is now AI driven. So there are a lot of IP issues discuss going on. So once again, I thank Eeva and also Roots IP for collaborating with us, and wishing you all very best in your IP journey. I also request all to stay connected with the NIMSME for more such knowledge sharing sessions, and have a great day ahead.
Yeah, thank you, ma'am. Thank you so much, Swapna Garu. So in the chat, there is a feedback link regarding the webinar. We request all the participants who wish to have their certificate emailed to you, the digital participation certificate. Please make sure you fill the form. And also, if you'd like to have the replay, you can go to the link which is in the chat. So we'll end this session with the YouTube link. In fact, the YouTube link is also put in the chat. Thank you so much, Kiran Kumar Gurram, for that quick note, and Jitendra Parmarji. So please make sure you watch the Guinness Book World Record holder, Sri Veena Panigaru, sharing his insights. The YouTube link is put in the chat. And we will also mail the link to all the registered participants, and all the speakers' LinkedIn profiles and their email IDs and contact numbers will be shared with all the registered participants. So let me share the link once again, as Lakshmi ma'am was asking. But a big thank you. Most of you can be the future speakers, all the 69 speakers, 69 participants right now. You can definitely be a speaker in IPR topic. That's our promise to you. Stay tuned. Keep following all the pages which are there in the registration page. We'll make sure we'll stay in touch with you, and you'll be seeing, as Srinivas Madhipatigaru mentioned, we'll come up with quarterly and monthly online and offline sessions, so you get to have more insights. So once again, big thank you for everybody. We'll see you soon. Bye-bye. Take care.